Commissioner Matolo Depu, Judge President Mlambo is back on his seat, waiting for you.
Thank you, Acting President. Good afternoon, JP. Okay, before I start, I need to make a declare that Justice Mlambo was one of my mentors. She is actually the person who taught me judicial skills, and it was a group of women when it was not fashionable to empower women. And I think we were about 5 or 6. And most of the judges who were there didn't want to deal with us because they thought they didn't want to go into the same lift with us because we were making noise, but he took us on. So I want to declare that. Secondly, Justice Mlambo, I want us to go to your pillars. No? I know that you are a champion of access to justice, and also that you really do care for unrepresented litigants. But what I just wanted to find out from you, if you can just elaborate more, can't we use, I know that the ineffective maintenance courts worry you. Shouldn't we use mediation to intervene in those matters, and especially in the maintenance court? And one of the things that I know, the profession offered themselves to go to maintenance courts to try and assist. And another thing, the profession offered themselves to go and teach police officers how to take statements that relate to sexual harassment or gender-based violence. But I just wanted to share you how can we fast track the issue of mediation, especially in the lower courts that can still work, according to me.
Thank you very much for the question, Commissioner Lepu. Yes, mediation is one of my pillars, is in one of my pillars, that is the judicial operations pillar, in terms of an option that can be used to alleviate workloads in the courts. You know, we have the Rule 41A initiative that comes from the Rules Board, but the application of that rule, which introduces mediation, has not been very successful. I chair a subcommittee of the Law Reform Commission that's tasked with coming up with a mediation bill for South Africa. And we had an engagement with the Nigerian judiciary where they have a multi-door mediation program. It is highly successful, run by female judges, very successful. So I'm citing this Nigerian example to say good practice exists in this continent, that mediation can assist in dispute resolution. It's a function of an engagement, and when I say an engagement, you say members of the profession offer themselves. I would be interested to know, because had it been in my court, I would have embraced it, and we'll find a way of how we select matters and select them, but get the buy-in of the legal profession to say, once our matters have been selected to go to mediation, we will consent, because that's the other aspect. We need buy-in from the other role players. So, up front, I agree with you that mediation can help, and I agree with you that properly structured engagement between the key role stakeholders, the profession, the judiciary, and the officials of the Department of Justice, especially when we talk about the maintenance courts. That's important if we can all come to the table and understand where the blockages are and actually put mediation in there. Because as you know, maintenance courts issues, it takes a long time before a matter reaches a maintenance court stage. There's a lot of dilly-dallying, avoiding and whatever until people lose hope. But yes, I think Once both parties are engaged and they are brought to a mediation table, I think a lot can be achieved in terms of obtaining fast resolution of maintenance claims.
Okay, I think my second issue I want to hear you on is the developing the jurisprudence on socio-economic circumstances that affect South Africa. And one of the things that I still maintain that we haven't developed South African law as South African law. And saying that, I always feel that we seem to look at our customary law as one of those things. It's like a pain and not elevate it to where it's supposed to be. So how do you think this can actually go into, especially even with the African countries, because we are on the same culture, the same thing that, how do we have those synergies of developing South African law in line with African law? I just want to hear your take on that.
Perhaps we can start with the traditional courts bill. That's been a bill for I don't know how many years. I've been on public platforms talking about the development of customary law to say it needs to be taken seriously because it is our law as Africans. And we need to ensure we stop people who have no interest in the development of African law dictating terms to us about how we can apply African law. It's a very involved court space. I can do as much, I can talk in public platforms, but I think we've got lawmakers in this room whose task it is to make sure that some of these laws see the light of day. So I would encourage our lawmakers to confront this issue because it's reality. I paid lobola for my wife, and lobola follows customary law rules, isn't it? My son paid lobola, and the engagement between the two families and the discussion around the table tells me that African law and culture is alive amongst us. So what is stopping us from ensuring that it goes a step further? I remember talking to judges in Botswana when they were talking about their traditional court criminal justice system. They made one admission that true African law has no jails, or true African law doesn't sentence people to jail. It's all based on conciliation. But that was their situation there because they have an interest in cattle theft. Therefore, the penal provisions of their customary law help their interests, but doesn't help the interest of the whole country. So I'm just citing that example to say we need to be bold as Africans to ensure that our law is not dictated to by outsiders. The history of the traditional courts bill being stuck where it is testifies to that fact, that we may have allowed a lot of external interests to stop the process, or to stymie the process, if I may use that word. So it is important, I agree with you, that as an African people and as representatives of a lot of people who are voiceless, we need to find a way to speed up these processes and ensure that, especially African law, finds its equal placing in the South African law books and statute books.
Thank you. Lastly, I just want to, it's a question that I want to pose on you on the al-Bashir matter. It was a case that shook the country and everybody. But what I just want to hear from you, what learnings as South Africans should we have gotten out of that case, especially with the international treaties and international laws that we sign? And most of people in the country don't even know that we've got those agreements with international organizations.
It's a function of educating society about what we do as arms of government. The Rome Statute is law in South Africa. They took the Rome Statute from the international arena and domesticated it and became law here in South Africa. As long as it conforms to our constitution, it is law here and it has to be applied. And it is for that reason that the court took the decision it took. So it's a question of us when we sign and have these obligations, just like the SADC tribunal case. South Africa's assent of the act that confirmed that South Africa as a state party is a signatory to the SADC tribunal. I think I'll call it the protocol. We as members of the three arms of government need to properly understand what we sign, what the implications are in what we sign, and what our responsibilities are arising from what we sign in the international arena. I think that's all I can say. I can't take it further than that.
Lastly, I just want to, I know that you were a proponent of assisting with making sure that briefing patterns are elevated.
Yes.
And you're taking steps to try and assist that it's true that briefing patterns are unequal. So if you were to be elected at the CJ, will you still proceed with that program? Because it really helped us and we had confidence that somebody up there is actually looking at it.
Certainly, I will restart the process. I took those steps until, I can't remember how many years ago, probably 3 or 4 years ago. But those who wanted those texts, I provided those texts. But there was one reason I did it as head of court was, we talk about briefing patterns in this commission, in public platforms, but we talk without any empirical evidence. So I said as head of court, I'm in a position where I can ensure that in each of the matters that appear, the legal representation is clear. So all that has to happen is the court clerks were to translate that legal information as to the race and gender of the people appearing there. In the unopposed motion courts, opposed motion courts, special motions, you name it. I had those texts and they confirmed overwhelmingly, especially when it comes to the banks, that most of the people who were briefed by the banks were white law firms, which translated into white male advocates in the main. I mean, at some stage in that process, perhaps I was out of line, but I asked for a meeting with the Standard Bank because there are a lot of Standard Bank matters that come to the courts. Fortunately, the CEO is someone who served articles under me when I was at Bowman's. So they acceded to the meeting. Because I just wanted to ask, how is it that them as a big bank, all their work is done by white professionals? Are they saying black professionals can do the work or not? You know, I had that engagement, but I stopped. I didn't go to other banks because I don't think it's actually my place as head of court to do that. I think it's for the leaders of the professions to actually undertake those interrogations. Because once you have the empirical evidence, it's not easy for people to deny that this is happening. And it's easy then to try and find ways of how to address that problem. Yes, by all means, it's something that I can gladly go back to.
Thank you, Justice Mlambo. Thank you,
Thank you, Commissioner Matolo. Commissioner Shabangu Mdawe.
Thank you, Acting President. Good afternoon, JP.
Good afternoon, Commissioner.
And how are you?
I'm trying my best under the circumstances, Commissioner. Thank you.
JP, I know a lot has been said under transformation, but I want to align myself with the comment made by Nadel that you are an epitome of transformation, that since you became a judge, you were giving, or you are still giving opportunities to women to come and act as judges. And I must confirm that we are one of that organization that approached you to give you a list of names of our members who we thought were able to or were ready to come and act. And you assisted us in that regard. And those members, they came back to report to us the assistance that you were giving to them and the support that you were giving to them. And you also in 2021 arranged a very intense training through SABC where you trained those women. I don't know whether you want to say something on that one, JP.
Thank you very much for that credit, Commissioner Shabangu. I confirm that I continue to find ways to advance transformation, because in my book, transformation is not only changing the color and gender of the people we bring to the bar, but to the bench, but also to ensure that once they are on the bench, we empower them to go even further in their careers. When I say further, it's like when you come to act, I must ensure that you always get a good spread of the work that comes, and you also have a chance at doing what is called difficult work. So I confirm what you've just said about those efforts. Unfortunately, there are other judges who are like-minded, especially on the training aspect, who heeded the call to ensure that we arrange that training program, and it went a long way. We need to arrange another one.
Thank you, JP, and on behalf of my organization, we like to thank you on that one. JP, you spoke about courts, and you mentioned some of them. It is a fact that sexual offenses take time to be finalized in the courts, whether in the lower courts and high courts. And also family law matters. They find themselves being heard by not so conversant magistrate or judges in family law matters issues. What is your take on the idea that maybe we need to have specialized sexual offenses court and family law court where we will have a well-trained magistrate and judges who will be hearing those matters?
I think insofar as sexual offenses courts, you'll remember that some time ago we did have these courts. And I think they were brought to an end. I can't remember if that was long, my early days on the bench. It was based on an outcry that they were centers where fair trial rights were not applied because of the speed at which those matters were handled. Because I understood that the prosecution had dedicated teams that upon arrest, they would start investigating to ensure that they fast-track the placement of those matters on the roll. I think that was then. I've not kept track with the issue of sexual offenses courts, but I think for me the problem lies elsewhere. The problem lies with case management. In almost all the high courts, we've got the trial role and the pre-trial role. And we introduced the pre-trial role deliberately because when matters are transferred from the lower courts to the high courts, when they land on the high court role, they are not ready to run. It is for that reason that, especially in my division, Gauteng, when a matter is transferred from the lower court to Gauteng, it doesn't land on the trial role because we know it won't run. It lands on the pre-trial role, and it is allocated to a judge. And the judge will case manage it until it's trial ready. Once it's trial ready, the case then gets put onto the trial roll. And when it's put there, it's ready. In all respects, it runs. So I think, to me, the slow movement of cases is we need to instill a bigger sense of using case management. That's about the criminal trial role, because that's where the sexual offenses fall in. It would be good if we could have specialist sexual offenses courts, especially, as you put it, where we have knowledgeable judicial officers who know or specialize in that type of area. I think it would be good. I say so because in Gauteng, we have a dedicated family law role. It started more with Rule 43s. But I think 2 terms ago, if not 3 terms ago, we actually ensured that instead of having 1 judge per week on the family law role, we have 2. That all trials that are on the civil trial role that are family law orientated were simply cascaded onto the family law role. And that worked wonderfully. And I was lucky in that term because all the people that are allocated to that role were family law specialists, right? And it assisted in ensuring that those matters are ahead and fast-tracked and resolved very quickly. So, in answer to your question, I think I would offer those comments, Commissioner Shabangu.
Thank you, JP. My next question, JP, you alluded to the fact that Gauteng Division has sexual harassment policy.
Yes.
Yesterday we heard that the judiciary doesn't have even the maternity leave policy. And by the look of things, you are attracting young female judges who still have to start their families. If there's no maternity leave policy, I don't know how they're going to survive. If appointed as the Chief Justice, do you think maybe you can make some efforts that this policy is also in place, and also consider your division also? Because I didn't hear you talking about it.
It's true that the bench now is attracting more younger and younger judges. And in the transformation program that I mentioned, it would be good to also have that issue of dealing with maternity issues. Let me put it that way. I have in mind I think I've read that the Cape Bar has a maternity policy that sort of prevented the disastrous effect of members going off on maternity and coming back and finding that they'd accumulated serious debts in terms of bar fees, etc., etc. So it would be a good initiative to also look at the issue of maternity benefits. You heard me when I said in the 4th pillar that I talked about that there is an aspect where one has to do with internal health and welfare issues of judges. It is under that aspect that I think it can be done. Although I may mention, my last 2 daughters were born when I was a judge. I remember when my daughter, who's 23, was born, it sent shockwaves on the bench to say, we still have judges who are getting children, you know. But yes, if the bench continues to attract younger judges, it's an aspect that we need to think about and implement.
JP, my last question. Earlier on, you were asked about allegation of sexual harassment. Were you made aware that you were going to be asked questions regarding these allegations?
No.
Thank you, JP.
Follow up, Acting Deputy President.
Thank you, Commissioner Shabangu Mdawe.
Follow up.
Yes, Commissioner Malema.
JP, earlier on you were asked a question about you running away from the Supreme Court of Appeal. Were you made aware that you're going to be asked such a question?
No.
Thank you.
Maybe follow up, Acting President.
Yes, you may proceed, Honorable Minister.
JP, what is the convention of this commission on allegations that they may want to ask candidates that you are aware? I know you have been a member of this sitting.
Well, from where I sit and having participated in the affairs of this commission, if there is no complaint in writing against a candidate, or if there is nothing in writing and the candidate has not been warned that an issue of that nature will be raised with her, it is never raised with the candidate. That's what I know to be the operations of this commission.
Thank you, Acting President.
May I please have a follow-up, Acting President?
Thank you, Honorable Minister. Yes, you may, advocate.
Thank you. Justice Mlambo, during the lunch adjournment and even now, there are messages flooding into my WhatsApp. Many of the judges serving in your division, and I'm just seeing whether I have leave to mention their names specifically before I do so, many senior counsel at the bar and juniors are all raising the issue that has just been addressed. I'll read one such message as an example. I've never been told by an attorney, advocate, clerk, aspirant judge, acting judge, or judge of any improper language or behavior on the part of JP Mlambo. I am a known feminist and was a senior judge and most likely person to have been so approached had there been any such behavior. Rumors have been started. The agenda is suspicious. If there's no complaint, there can be nothing to discuss, comment, or act upon. Similarly, many of the judges and members of the bar mentioned that they are the kind of people that have acted in women's interests for many years and would have been approached had any woman within the realm of the judges or advocates profession had been the experience or recipient of anything untoward on your behalf. And many of the messages are to the effect that these women have worked with you for many years and found you to be a person with whom they feel safe and supported. Thank you, Acting President.
Thank you, Commissioner Kane.
President, can you just a point of order? Are we now going to be allowed to read all the messages that we receive from people? Because we are also receiving messages.
I have a message as well, I can read it.
As we speak, no, because if this is going to go on and on and on like this, we're going to be really running in circles. Really, I'm receiving so many messages.
Yes, I take your point, Commissioner Madonsela.
So
I think that's a matter. If commissioners, the point has been exhausted with the candidate, and if anything arises out of that, perhaps it would be best to reserve whatever we say, and we can debate about this during our deliberations. Thank you. Professor Schlema.
Thank you, Acting President. Good afternoon, sir.
Good afternoon, Prof.
I really liked most of the things that you said about in your vision for the judiciary. I think they are laudable. And if we were to have a Chief Justice that can implement these things, it will be to the benefit of South Africa and the judiciary as a whole. And linked to that, I would just like to ask you a couple of questions on some of the things that you said. Yes. One of the things that really interests me is how do you see the single judiciary function? Are you thinking of something like a professional career as a judge? How do you see the single judiciary?
Well, thank you, Commissioner Schlema. The single judiciary concept that I mentioned when I made my presentation is to just say the issue of the magistrates still being fully under the executive and not being fully with the OCJ is an issue that must be addressed, because magistrates are judicial officers. In fact, when they commented on the institutional model that I mentioned earlier, they also mentioned that they are judicial officers like judges and would like to be under one home and one roof like judges. So I mentioned it in that aspect. Look, if I come to whether I was thinking of it as a professional line, I think the way things work as we speak, people practice law, and then when they feel they want to be members of the judiciary, they avail themselves for acting stints, and then they apply for appointments. I know there are countries where that is a professional track, where you don't even go into practice, you go straight, you know. But I don't think I was talking about that. I was just talking about having one arm with all judicial officers as judges, because in other countries you've got magistrates called judges.
Thank you for that. Linked, I think, to having just a single judiciary and having everyone then under the umbrella of the OCJ will mean a lot of additional money will have to go in that direction.
Yes.
Now, linked to that is the question that the Minister asked you about Section 52, I think it was, of the Superior Courts Act, in terms of which it seems, and if I understood the Minister yesterday correctly, it has never happened that this Chief Justice have come with specific requests to the Minister, which he must then consider when it comes to additional funding for the judiciary. How would you approach this if you were to be the Chief Justice? The issue of the budget, where you are entitled to, and the Minister must then consider and address the requests.
Commissioner Schlema, I did mention that there's phase 2, where those issues will be pertinent to be addressed. The Minister was correct when he read that section. Phase 2 is where the judiciary leadership engages the executive and charts out the way to total judicial independence. And not only judicial independence in terms of judicial functions, but totally in terms of operations as well. So the Minister said the document is with Cabinet, or it's further than that the executive is preparing to engage the judiciary. So I would say I would look forward to see what is in the mind of the executive in going on that path. Because you're correct, were the magistrates to come under the OCJ, it has serious budgetary constraints, right? And that's all envisaged in phase 2, to say what increased budget are we looking for, and how do we place the necessary support structures to ensure that the magistrates are also supported like judges are being supported. So I'm not sure I'll be able to answer. All I can say is, yes, it's an aspect that's on the table, phase 2. Budget, right now we do get a budget, and the Minister of Justice is the one who speaks to Parliament about our budget, right? So once we engage, this toing and froing will hopefully come to an end. I undertake to ensure that if I'm appointed, that things go according to how we as the leadership of the judiciary, with the members of the judiciary, see how things should be. Because I think it's a consultative process. I mentioned the colloquium. You know, after the OCJ was declared, we should ideally have had a colloquium for members of the judiciary to understand we now have one step in that direction, but it's only the superior judiciary. The lower judiciary is still outside. What is entailed? What are the time frames and the thinking in terms of going the next step? That's why I said, as Chief Justice, it's something that I will ensure I look at, and I ensure that there's discussion that is goal-driven.
Thank you for that. Another aspect that you mentioned that's also going to require, I think, fair amount of additional money is the improvement of jurisprudential excellence, and also you spoke about the capacitation of the intellectual capacity of judges.
Yes.
How do you envisage, you spoke about continuous judicial training through SAJE, for instance. What exactly do you have in mind, and how do you think will it be achieved?
Well, there are two aspects that I can speak about. There are budgetary issues regarding the accessibility of online libraries or online research engines that the judiciary can access. That needs to be addressed, right? So that the research needs of the judiciary are not restricted by the sites that they can access and those that they can't access. So that's capacitation on that front. And there's a subcommittee of heads of courts called the Law Reporting Committee. JP Tlaletsi serves on it. It is meant to come up with a judiciary law report. We have countries that have judiciaries that have their law reports. I like to refer to what Chief Justice Mogoeng always says, to say, we spend time hearing matters, doing research, writing judgments. The next thing, those judgments are sent to outside agencies who print and polish and reprint them and sell them back to us. We need to address that, to say that money can come in handy regarding other aspects of our needs. So it's a project that I think needs to continue. It was stopped by COVID, because when COVID struck, there was an educational tour meant for Kenya to observe their law reporting processes there. So I'm saying access to proper, relevant research engine sites, and the complete development which will ensure easy accessibility of law reports and judgments is an issue that needs to be sped up, in addition to the continued judicial education programs I mentioned. But there's also a case for seminars, judicial seminars where we share the platform with legal scholars, because it's all aimed at ensuring that our jurisprudence develops in such a way that it is relevant to South African society. I think that's the message I'm trying to send out.
Thank you for that. Just my last question, and maybe we should speak about this offline as well. You finished your LLB in 2019.
Yes.
What was your experience with the LLB as a sitting judge, the content that we offer students? If you don't want to answer in public, that's fine. Then we can do it offline, but I would like to hear your views on that.
I can answer. My problem is, because I came with a lot of practical experience of applying the law, I found that I would be given low marks, because when I answer a question, I come with a practical take of things. That's how this law is applied. And you have young lecturers who've never practiced law, who think, no, the study guide doesn't talk about this thing. Where are you coming from? So that was my experience. Especially with labor law, I was very angry, because I would get 52, 53, yet I thought that was my specialist area.
Thank you, JP. Thank you.
Thank you, Professor Slem. Commissioner Makwanise.
No, thank you very much, Acting President. I think we have brought relief in me, Judge President. Tina Bomadoda score.
Yes.
I think we're at par with judges. No, thank you very much. Just few issues. Under institutional model, I'm not sure whether I heard you correctly when you were doing the benchmarking. You said something to the effect of operationally, you want to benchmark it around the Office of the Attorney General. Did I hear you correctly?
The Auditor General.
Auditor General.
That's correct. That's what's in the institutional model document that we have.
Okay.
Yes.
I thought you said Attorney General. I was going to have a challenge. And then the other issue that I would like to get your views on. You said earlier on you give opportunity to advocates, attorneys, and academics. I know that there has been the discussion in the JSC about prosecutors and state advocates. What are your views as the possible incoming Chief Justice around that?
Thank you for the question, Commissioner Magwanishe. I think what needs to be added are magistrates, because when we have a single judiciary concept, it is a career path for magistrates to also come to the higher superior, the superior courts. And I have had a number of magistrates acting, and some of them appointed permanently. So I just wanted to add that they are also in the equation. The issue of state lawyers, if I may use that term, and you use prosecutors, but I have in mind that it's a broader context. The broader context. You have state law advisors. I mean, the former chief state law advisor is acting in the division as we speak, but he had to retire from the department for him to be eligible to be appointed to act. Simply because the professions, especially the advocates' professions, have made serious objections to the appointment of state lawyers. Pardon me for using that term, but I think I may be found remiss for using that term. And it's an issue that has been discussed at heads of courts level. And I would want to be reminded, but I think there's currently an embargo against the appointment of state lawyers. When you put it to prosecutors, the only time they are appointed is when they retire. I've had a number of former state advocates when they go into retirement to help in the criminal law courts, because that's where their experience is based. So it's an issue that we've discussed, and we've said it needs to be revisited and discussed to see if there is scope to appoint state lawyers. I mean, the objection at appointing state lawyers is that they would be sympathetic to government and they will be executive-minded. That's the objection. I want to reserve my comment about whether that concern is founded or not. But that's the situation as we speak. And probably as Chief Justice, if I'm appointed, that issue needs to come back onto the table, and the professional bodies need to be brought to the table to discuss this if there are still, or if the problems remain that state lawyers cannot be appointed. I'm not saying there's no merit to the concern raised by the professional bodies. That's why I say I'll refrain from expressing a view about it. But it's an issue that needs to be discussed, because you can't dictate how things should be. I mean, the professions, the NPA, are all relevant court stakeholders. It's a matter that requires all of them to sit together and see how they resolve it.
Thank you very much, Judge President. I think when you were articulating your vision, you made mention of the issue of the welfare of the judiciary.
Yes.
But I thought you were very broad. In your experience of over 20 years, what do you think are the main issues that need to be addressed that affect the judiciary in terms of their welfare?
Thanks for the question, Commissioner Magwanishe. I think one aspect has to do with the availability of appropriate tools of trade. When I talk about tools of trade, I would talk about when COVID hit, I was shocked that there were judges who had 10-year or longer laptops whose webcams were no longer operational. So there needs to be a proper system where once a laptop, just as an example, reaches its sell-by date after 3 years, that it's replaced, not depending on you asking for it. That there needs to be a system that identifies that these tools are now obsolete, they need to be replaced. I remember saying for Gauteng we no longer want hard copy calendars and diaries, because I said you can use electronic diaries. That's on your laptop that the state buys for you. Why do you need an extra? So the budget for those things need to be redirected to other needs of the judiciary. So tools of trade is one aspect. I mentioned access to relevant law research engines. I mentioned the proper capacitation of the research capacity that supports judges, right? So that you alleviate judges from doing the initial research on their work. Then there are the so-called soft issues. So-called soft issues like our medical aid, to start with. I think it was Commissioner Shabangu Mdawe who mentioned maternity benefits. When I joined the judiciary, our medical aid at Parliament I was paying a third and the 2/3 was subsidized. But the situation now is the other way. I know that the EFF took a case, I don't know what's happened to that case, about challenging the Parliament arrangement. But it's a problem. Last year in particular, there were a number of problems that were experienced by judges regarding Parliament. Like you go to particular medical service providers, you pay cash, you request a refund, you wait long, sometimes you don't get that refund. Those are issues that can be resolved, but we need to go back to basics and understand our benefit level regarding access to medical aid. If you're bringing a younger bench, that's a very relevant issue to look at and see how it's resolved. And there's then the vexed issue of the salaries of judges. I mention it because it is an aspect that has been mentioned to me, and I know to other heads of courts, that the way this issue has been treated is dissuading people who may be interested in coming to the bench who won't come because of the salary structure, the salary levels. So the unfortunate part is it's been a long time. The judicial salary structure always goes through a review every 8 to 10 years. The last time the judicial salaries were reviewed was, I think, 2007, if I'm not mistaken. We are now in 2022. I know that the commission that's looking at the salaries of office bearers is still at it, but it's been long that it's been at it. I think it's a relevant issue that needs to be looked at. So let me stop there because I don't want to waffle along until I'm stopped that I'm talking too much. I just thought let me mention those issues.
Thank you, Acting President. Thank you, JP.
Thank you, Commissioner Magwanisha. Commissioner Moimang.
Thank you, Acting President. Good afternoon, JP.
Good afternoon, Commissioner Moimang.
At the beginning of your vision that you presented to the Commission, you gave the context as a preamble to those 7 pillars.
Yes.
And you referred it to also as scanning the environment. Now, The question that I want to pose related to that is relates to your second pillar, where you said there is a need to rightfully assert the place of the judicial arm of government along the other two arms of government. Now, the question that I want to pose, particularly with the commitment to strengthen the role of the judiciary along the same line as the executive and the legislative arm of government, relates to one of the objections that was raised and how you dealt with it. Objection 2 from the PP was a request to tamper with the panel that you had allocated to deal with one of the matters that involved the public protector, and you positively acceded to that request, the request to remove Judge Fabricius. Now, the question that I want to pose is, by so doing, was that not in conflict with the clear proclamation by Section 165 about protecting the independence of the judiciary? And can any litigant make a request, approach JP's office to say, I don't want this judge, can you replace him with this other one? Thank you.
Thank you very much for that question, Commissioner Moimang. In the request by the PP's office for me to consider removing Judge Fabricius from the panel, it's a letter I received from the PP's lawyers, legal representatives. They motivated a case that was well-founded to me in my assessment, that there was a perception of bias on the part of Judge Fabricius. And it happens every day. When a case is made out that this judge has expressed himself in this fashion, in this matter, it tells me as a litigant that I'm not going to get a fair hearing from this judge. It's a legitimate concern that I have to take on board. And it was on that basis that I found that it was perception, not that the judge was biased, but if it is raised with me, to avoid a full-blown recusal hearing, let me do it as requested and ensure that another judge replaces him. That does not interfere or threaten judicial independence. It's my function as head of court to be alive to requests of this nature when they come to me.
Thank you, JP. The second question relates to the point that was raised earlier on around the perception of a biasness towards the executive arm of government, particularly with regard to some of the judgment that was presided over by JP. The one that comes to my mind that prompted me to pose this question to you. What is the difference between judicial overreach and judicial restraint? Because others accuse the judiciary of being of legislating from the bench, and there are instances where you expect the court to give a line of march, and then the court takes a back seat. If you can just probably make a distinction between those two. But prior to that, let me just, because in the case of that you made reference to when you responded, the Minister of Finance versus Ogday, the court refused to give a declaratory order that the minister has no obligation and right to interfere in a relationship between a bank and its client, because the court said that is a moot point. All of us know that the executive authority has the authority to tell the bank what is the position of the law. If you can just make a distinction between judicial restraint and judicial overreach. Thank you.
Thank you very much, Commissioner Moimong. Judicial restraint is when the judiciary must be cautious not to stray onto the terrain, to exercise that restraint on itself from delving into the terrain of another arm of government, which would translate into overreach if it happened. There are instances, and that's why the constitutional arrangement, I think in section 172 of the Constitution, if I'm mistaken, to say if there will be separation of arms harm, the Constitutional Court as the highest court is the one who needs to ensure that it has explored and a proper case has been made for it to go to the extent it goes to. So judicial restraint is simply to say, as the judiciary, we need to know that we police our boundaries and we are restrained in terms of not interfering with the affairs of the other arms of government. I think Justice Moseneke expressed this principle very aptly in the outer judgment, where he reversed an interim interdict that was granted by the Pretoria High Court against the e-toll program. So that's judicial restraint. And as I say, judicial overreach is where the judicial arm of government goes into the terrain of another arm of government and actually starts dictating to that arm how it should go about doing its work, which is not allowed. The judiciary can't do that. If it's called upon on review to pronounce on probably the legality of some executive conduct or executive action, it needs to ensure that if it finds that it will set it aside, it cannot then itself say this is what should be done. It should defer to that arm of government to do what it's meant to do. Let me stop there.
Thank you, Acting President. The reason why I posed this question is in relation to the fact that earlier on you mentioned the Al-Bashir case.
Yes.
As one of the judgment that you listed as a reference point.
Yes.
What would you say if one says that in that case of Al-Bashir, given the fact that the AU had convened the AU meeting in South Africa, it was not a South Africa conference, but the AU had used the venue of South Africa for the head of states to meet. And in terms of Chapter 7 of the National Development Plan, it is categorical in terms of what guides the foreign policy of our country. It says the gateway to the international or global world is through Africa. And what is quite critical is the national interest as a starting point. And in that situation, those South Africa had signed that treaty that put an obligation on South Africa to arrest al-Bashir. But given its national interest, given the fact that the gateway to the ICC itself is definitely AU, don't you think that the court should have treated the matter with restraint? Thank you.
Well, the court didn't treat the matter with the restraint that you are articulating. I think the court simply focused on the facts before it. If you'll recall, Commissioner Moimang, trying to recall the facts of that case, the executive arm of government tried to guarantee the immunity from arrest of visiting heads of state based on a regulation, if I'm not mistaken. Now, the debate that raged on in the court was, can a regulation, temporary as it was, override an act of parliament that has clearly spelled out responsibilities? And the court felt no, it can't. Because the act of parliament is very clear. We've signed this. These are the responsibilities we have as a signatory to the Rome Statute. So I don't think there was any scope to exercise restraint in those circumstances. And in any way, the horse has bolted because the Supreme Court of Appeal upheld that judgment.
Thank you, JP. Thank you, Acting President.
Thank you, Commissioner Moiman. I make it 5-4 now. And as I indicated earlier on when I made my housekeeping announcements, we are required to adjourn at 4, just before load shedding kicks in, after which the IT team will reset things, and then we can resume at 4:30. Can I appeal to the commissioners who still have questions to ask? I think about 9 of them, to please streamline their questions and possible, not preface your questions with long prelude unless it is absolutely necessary. Thank you. We'll adjourn at this stage and resume at 4:30. Yes,
Yeah.
Commissioner Mpofu.
Thank you very much, Acting President. No, I wanted to ask you, just so that I hear what you're saying. I thought I would try and make this follow-up right at the end, but if we are running out of time, if you can just give me the remaining 5 minutes just to deal with something very quickly.
By all means.
Thank you. Thank you very much. JP?
Advocate Mpofu.
Yes, this will take literally about 5 minutes because I'm going to pose it mostly as yes and no answers. You agree that 2 of the most serious scourges in this society are corruption and gender-based violence?
Yes.
Commissioner Madonsela asked you about allegations of corruption and rumors that you are biased in favor of Ramaphosa, President Ramaphosa, correct?
Yes.
If that was true, if those rumors were true, it would be serious and an impeachable offense.
Yes, if they can be proven and if they can be articulated.
Yes.
Yes.
And were you told before the interview that you'll be asked that serious question?
No.
Commissioner Kane asked you about rumors about judges taking brown envelopes or kickbacks. Remember that?
No. Remind me, please.
Well, she said when she and I were leading the bar.
Oh, I see.
There was an issue about judges taking kickbacks.
Yes. I remember it.
Again, if that is true, that would be an impeachable offense, correct?
If it is true, yes.
Yes. Were you told before the interviews that you'll be asked that question?
No.
And then I asked you about gender-based violence allegations, at least. And again, if true, that would be impeachable.
Yes.
Now, do you think that we will ever overcome the scourge of gender-based violence in particular if that issue is treated in such a way that it, unlike all the other serious issues, must be hushed, and those rumors, and if women in particular are suggesting that an issue of that seriousness should not be raised so that you can clear the air. Is that the correct approach?
Sorry,
I
Chair,
don't
if this is
understand the
supposed to
question.
be my suggestion, it certainly isn't.
But he never said it's your suggestion.
Yeah,
He never mentioned your name. I'm not talking to you, Wenaman.
Yeah.
I'm not talking to you. We're not going to be harassed here by a journalist.
Commissioner Mlambo?
No, there's a journalist here. I don't know if she took a medication or what. Every time we speak here, she speaks here at the back. She must not do that.
I've noted.
Yeah, she comes
what
here
they
with
are
some
taking.
white tendency and she thinks she's superior than all of us here. I'm not going to take that from her.
I've heard you, Mr. Mlambo. I will ensure that that incident is dealt with appropriately.
Thank you, Chair. Can you protect me from the interruptions of this? Of
I think the best, let's take an
Commissioners.
adjournment now,
No,
because it's 4 o'clock already.
Well, unless I wanted to wrap this up now, if you're going to allow me to continue afterwards,
Sure.
then I will. I'd rather finish it now and get it over with.
Make it quick,
I only have
Commissioner.
a promise,
Yes,
Acting President.
thank you.
Yes. In fact, okay, then I'll wrap it up in one question. Do you accept that questions about serious allegations which may be impeachable offenses against a potential Chief Justice must be put to that person so that they can clear the air? And that does not mean that any of these persons, whether it was Commissioner Kane or Commissioner Madonsela or me for that matter, subscribe to that issue. I can put it out there that I don't think you are guilty of sexual harassment, but I will never be party to the suppression of any allegations of such a serious matter as gender-based violence. And I think it's only fair that you've confirmed that you were aware of these rumors before I raised them, correct?
Yes.
Yes. And that is all that has happened here. And the spirit
What do you
was-
want me to respond to? Advocate
No,
Bafo?
I'm asking you whether you agree or not that you should be given an opportunity to clear the air if such serious allegations are around. Yes or no?
I agree that I need
Thank
to be
you.
given an opportunity to clear the air, but the issue, and you can't just restrain me, Advocate Bafo.
No, I'm not.
The issue is the fairness of that. If the commission is aware of things like that, it's only fair that the candidate is warned beforehand to say, these issues are going to be raised with you. And when they are raised, it's only fair that these issues are documented properly from a member of the public or an identifiable whistleblower.
Yes.
It's a question of fairness,
Yeah,
Advocate Bafo.
Yes, no, except, but that
Yes.
fairness only attaches to gender-based violence, but not to corruption allegations.
It attaches to everything.
Thank you.
Yeah, and for the record, the issue of the brown envelopes is I was misquoted by a radio station as saying judges were
I
taking
know.
bribes. And that's why I forced them to retract, because I never said that.
Sure.
Thank you.
Thank you,
Thank you,
Commissioner Mpofu. Commissioner Shabangu, you will have to wait until after our resumption at 4:30, I'm afraid. Thank you. We are taking a 30 minutes adjournment at this stage.
Yeah,
Thanks.
I just put these whenever you feel like. Okay.
that fairness dictates that we should not have regard to those rumors. So in effect, my view is that the questions and answers, questions posed to him and answers given by Judge President Mlambo should be regarded as pro non scripto and be expunged from the record. The second one is directed to the members of the media. I would like to make an earnest appeal to them to observe and respect the decorum of the sittings of the Commission. No one amongst them is entitled to make any utterances in response to or retort to what members of the Commission say during the proceedings. I hope that that is clearly understood and that I will not find it necessary to make this announcement again. Thank you. Yes, Judge President Salaries.
Acting President, on the first issue, you say you take a view, and I would request you to make it clear that it is your ruling, so that there should not be debate that it's only a view that you expressed, and you should not revisit this issue again. Thank you.
Commissioner Club.
Yes, no, thank you very much. Indeed, any rumor that insinuates that women were promoted to positions got there via sexual favors is offensive and objectionable. And I, Vusmuzi Cyril Kaba, distance myself from such insinuation. It's regrettable that this was aired in this meeting, whereas without having primed their candidate that these matters were going to be aired in this meeting. In that way, I support you, Judge President, when you say you must expunge this from the record. Thank you.
Acting President, can we call order?
Yes, please.
You have made a ruling, and can we not discuss it further? If anyone is allowed to start a debate, everyone must be allowed. So can I request that your ruling be respected and we close this part of the debate?
Yes.
Thank you, Commissioner.
Acting President. Yes. Sorry.
There's nothing further to say except to emphasize that what I said earlier in relation to this issue is the ruling that I make.
Acting President. Yes.
Commissioner Mbofu.
Thank you. I'm supporting the fact that I think this matter, if we're going to have all these concurring judgments, it should be left to the deliberations at any level. Well, let's just move on and we'll deal with it during the deliberations.
Commissioner Mbofu, I've made a ruling.
Yes, thanks.
There's nothing to deliberate on in due course.
Well,
Commissioner Baba.
Acting President, good afternoon, and good afternoon to JP. JP, I just want to take you back to one of your pillars. You know, you spoke about the total independence of the judiciary. I must say I cringed when you made to total independence, because I know that.
Commissioner Klaba, sorry to interrupt you. I just want to ask you to please raise your voice. Some of us are hard of hearing.
Oh, yes. Thank you. Thank you. In your presentation, you referred to total independence of the judiciary. So I say, President, I cringed, because you see, because I know that there is no unanimity on the definition of judicial independence. And however, there is a common thread that runs through all the definitions, that talks about how the judges are appointed, security of tenure, how judicial complaints are handled, and how judges are removed from their position. And but taking it to the level where you even suggest that the judiciary must develop its own policy. Do we think that is the best way of addressing what we have seen as tension between or amongst the arms of state, and the other believing that there is encroachment into its space, while also the other as well also saying, look, our independence is undermined, or we're being there's interference with our jobs or responsibilities. Do you really honestly believe that this is the best way of dealing with with the issue of judicial independence, self-governance, as you put it in one of your documents?
Thank you very much, Commissioner Klaba. I expressed a statement that's in the document that I referred to. I don't know if Commissioner Klaba has read it or if you've seen it, but
it refers to self-governance, and that's a document which comes from that institutional models committee.
Yes. Now, I want to allay your fears that don't cringe when I say total independence. I think the road to wherever destination we want to go as a judiciary will be the subject of engagement and discussion. That is a stated position. But one aspect, if you've read that document, is when we are in phase 2, and if we go there, as currently crafted in the document, the way we account is dealt with there. That is, we will account in the same way as the Auditor General accounts, that there's a special select committee that the judiciary will account to. Now, and that will be accounting to Parliament. So that's one aspect that you say in the current model, the way it's crafted, that's how we're going to deal with accountability. So it doesn't suggest when I say total independence, because I thought that's the language I saw in the document that says the road to, or it says complete independence. I think that's what it says. It says complete independence. Judicial independence, that is, yeah. So, but it doesn't mean that we are unaccountable. We will be unaccountable. We'll have to find a way to account. And in any way, that's on the table. It's a position that we have adopted as members of the judiciary. And I don't think it can be taken as the final position. It's not. So maybe let me stop there and see if you are satisfied with what I'm saying or whether we can take it further. Yeah.
Well, I'm satisfied when you say that you took it from the document,
Yes.
which is now a stated position
Yes.
of the judiciary.
Yes.
But just to take the question further,
Yes.
so that I understand the document, does it in any way give examples of jurisdiction where there is total separation between or amongst the different or the various arms of government?
Yes, by all means, because this study was in-depth research and good practice, as they call it in the document. Examples were cited in terms of countries that have this model. I can't remember them offhand, but they are mentioned in the document, yes. There are countries that have that model.
No, thank you very much. My last question to you, you spoke about a functional judiciary that has lived up to the promise of the Constitution. Is it the view of the judiciary as a whole that the South African judiciary, the confidence in the South African judiciary is on the decline?
I was mentioning on indexes that are published about the views about the performance of the South African judiciary when I said I did an environmental scan. But overall, Commissioner Mlambo, I listened to radio stations, a number of them, and not only the so-called white radio stations. I listened to so-called black radio stations, and you hear disturbing comments from members of the public about perceptions they have, right, about the judiciary. Say that this is a corrupt judiciary. I had a case on that date, the docket vanish, or this is what happened to me, therefore this judiciary is not delivering. It's a common theme, and I was talking to that, and I'm being honest, because it worries me as a member of the judiciary to say, if this is a perception from out there, something drastic needs to be done to make sure that we present the correct picture, and if there are aspects that require attention to make sure that we restore that confidence in the judiciary to the levels that are, in our view, acceptable, we should do that. So that's where I come from. It could be perception, it could be, there are real facts. I mean, if you mention the maintenance area, Commissioner Mlambo, it's a matter that is of concern nationally, that maintenance courts are not serving their purpose. And clearly, with a situation like that, there cannot be confidence in members of the public who have not accessed justice there that the judiciary is performing, because they've experienced non-performance of the judiciary.
Thank you very much. The other questions have been covered, President. Thanks, JP.
Thanks, Commissioner Mlambo.
Thank you, Commissioner Mlambo. Commissioner Nyambi.
Thank you, Acting President. Afternoon, JP Mlambo.
Good evening, Commissioner Nyambi.
Oh, it's evening.
Oh, good afternoon, sorry, it's not 5 o'clock yet.
Thank you. How are you this afternoon?
That could be better. I had a cup of coffee, so it's pepped me up a bit.
Let me start by commending you for being able to have be the one leading the establishment of the Limpopo and Mpumalanga division. Probably as somebody who's running the busiest division in our country, if you can share with us that journey, how were you able to balance that?
Thank you, Commissioner Nyambi. I think I realized, and I made this point when I was interviewed for the position of Judge President of Gauteng, that I will not shy away from dirtying my hands in ensuring that the program of the judiciary happens. The Limpopo Division building project had come to a standstill for a number of years before I took over. And as I said, when I addressed the law societies or law professions in those provinces, I told them that my program is to work myself out of the job of being responsible for these provinces. They must have their own high courts and their own judges, President. That's what I mentioned. The starting block was to say to the professions in Limpopo, because there was a building, the old regional court structure that was used there, to say, instead of sending one judge once every 1 week every 6 weeks to attend to whatever civil work is there, I will send them permanent capacity every term, that they will be judged for the 10 weeks of the term. Not judge, not 1, 2. And there was a special roster in which the work would be done. That was to say to them, stop sending your work to Pretoria, issue here, and your work will be heard here. So to start saying to them, access to justice, the twin objective was to engage the Department of Public Works and the Department of Justice to say, let's put this thing back on the project. What happened? The contractors have left the site. What are the issues with the contractors? And all those things, just to make sure that building starts. I remember that when the tender was re-awarded, it was re-awarded, I think, to a company called Group 5. We're not involved as a judiciary in all those things. My interest was to see progress. And I used to go there, to go on site, and they used to ensure I wear safety clothing. I could share with you the pictures of me wearing the macarapas and the overalls just to go and see if things were happening. That's my way of ensuring that things happen, right? So with Mpumalanga as well, when I talked to them, that, look, you'll have a high court, they laughed at me. They say, you're joking. We'll never have a high court in Mpumalanga. But it's happened. So it's a question of being committed to make sure that you achieve this. And when I handed over to JP Makgoba, I said, thank you very much. Objective achieved. Last one is Mpumalanga. And when I handed over to JP Lukhodi, I was happy to say I'm now going to stay in Gauteng. So that's what I can say about why. It was a total commitment to ensuring that each province must have its own high court, functional, running, and guaranteeing access to justice to people of that province.
Thank you, JP. As we have explained the current challenges in terms of maintenance of those beautiful buildings, if you can be given the opportunity and be a CJ, what will be your immediate solution to those challenges faced by those beautiful buildings in these two divisions?
Thank you, Commissioner. I think the issue is, and that's the reality, as the OCJ, we need to work through the Department of Justice, which then goes to the Department of Public Works to ensure that these huge infrastructure projects find traction. That's how it works. And the first port of call, of course, is to ensure that there's an engagement with those departments. And I can assure you that in the PEEC structure that I chair in Gauteng, I mean, the Pretoria Magistrates Court was bent. When they were repairing it, they stopped, and mold developed in the roofing level. The Mamelodi Court was on standstill for many years. These are real infrastructural failures, if one may call that. So as Chief Justice, I'll have to energize that. And that's why I think, because I've seen that the question of pushing officials to do what they must do is a function of ensuring that leadership is committed to making sure that officials do what they must do. So PEC has failed in Gauteng. They've tried, they've given up. Soweto Court for some 6 months operated without water because they were sharing water with the police station next door. The court would only sit for about 2 hours a day. And if you went there after the court has adjourned, you wouldn't last 5 minutes because of how it smelled. I had to say to Acting Chief Justice Kampepe, please intervene. And they came to the party and they solved the water issues. So I'm saying it's a question of engaging the relevant stakeholders. That's why I said the NEEC, where the Director of Public Works, Director General of Public Works will be there. Director General of Justice will be there. Secretary General of OCJ will be there to say, you are the executing authorities. They give us the project execution plans and we will hold you liable if you don't meet your targets. So that's the way to go. Because if then there's a failure at NEEC level, that's when it will go to the meeting of the leaders of the three arms of government.
My last question is your view on law as a tool for social and economic justice.
Yes, it can play a very meaningful role in that regard. I can cite examples internationally and here at home that law can be used as a tool to advance socio-economic justice. I agree.
Thank you, JP Mlambo. Thank you, Acting President.
Thank you, Commissioner Nyambi. Commissioner Mapisa.
Thank you very much, Acting President. Good afternoon.
Good afternoon, Madam Speaker.
Judge President Mlambo. Are you okay though?
Under the circumstances, I'm trying to be okay, Madam
you.
Speaker.
Thank you. Now, the first question was the last part of Commissioner Nyambi, which I wanted to raise with you. The next issue is a matter which we've really been talking about, all of us here, which was raised even yesterday, about the fact that the judiciary does not have a sexual harassment policy, anti-sexual harassment policy. And this afternoon or earlier on, you raised it and you said, in fact, the only bar which has it is the Western Cape Bar. Am I correct?
Yes, and I also mentioned that in the Gauteng division, we have a sexual harassment policy.
Okay, all right. The issue of like...
Sorry,
yes,
sorry to disturb you. The Cape Bar policy I mentioned is a maternity benefits policy.
Maternity benefits. Yeah. Even that, I think, JP, we should urge you that in the event you were to be appointed, that you will ensure that this maternity policy is not just a maternity policy for the Western Cape, it should be across the country in the entire judiciary. Not just maternity, but also paternity.
Yes.
Yeah. Now, the next issue which you raised quite early in your submission, right at the beginning, before you even outlined the 7 pillars, you raised a matter which I thought I should take further with you and just seek clarity as whether it has impacted negatively in your work as the judiciary. And that is you mentioned that the environment is toxic at times and the political space is polarized.
Yes.
Have you felt the impact of this, and in what way? I think it would be interesting for me because you are correct. It's a toxic environment. Yes, it's a polarized political space out there, but I want to hear how it impacts on the judiciary.
Yes.
And your work as the judiciary.
Thank you for that question, Madam Speaker. I think, let me refer to one example that illustrates why I'm talking about that. When we had the July problems of looting and whatever, you will recall that there were threats that were made online and in voice notes against the judiciary. And there were threats made that the courts were going to be bent down. I am the head of a division that has many judges. Some of them female, single-headed and run. And judges called me to say, JP, we feel threatened. Because some of the voice notes said we know where these judges live. Another example, and I'll mention it because you've asked me the question, and this goes deep into like judges' wellness, judges' security. When the judge who had the former president's case here, Judge Matojane, I'll mention him by name. You will remember after the ruling that there were vicious threats issued against him personally. I don't know how many times I had to speak to him and assure him because he was really worried. We even got SABs to go and make sure that they keep vigilance around him because the threats issued against him were seriously worrying. Now, this is the impact. If judges are going to feel that level of threats against themselves personally, what do you think they will do when they get confronted with these cases? Doesn't that erode their independence and impartiality? Are they not going to start ruling in a way that says they are not going to be threatened? It worries me. It worries me deeply. And I think as head of the judiciary, if I'm appointed, it's an issue that needs to be emphasized because these threats mostly have got political undertones. That's why I said political, polarized political arena. Because that's where they come from. There needs to be a serious discussion by the leadership of this country to say, how do we effectively deal with this? Because we can't just let them say, no, these are hotheads just talking, it's not going to go anything. It erodes our own confidence as judges that we can do our work without fear, favor, or prejudice. I just thought, let me give you that one example as to the effect on us.
Thank you very much. Judge President. And then there was another matter which you raised, which I found very interesting, and that is the perception of South Africans on the Constitution of the Republic of South Africa. How would you deal with that?
Thank you for the question once more, Madam Speaker. I raised it. You will remember, Madam Speaker, that when there were the Fees Must Fall campaign, almost every student leader said this constitution has not served us. And some of them went as far as suggesting that former President Nelson Mandela sold out. We are alive to this, we hear them. And it worries us because this is a document that was achieved, as I said earlier, out of sweat and blood of a lot of people. So if there are people who will feel that this constitution has not delivered and it's not delivering, it should worry any South African. And we should explore in what respect it hasn't. And sitting from where I sit, I think there's some credence to not saying the constitution has failed, but to say the delivery of some of the constitutional promises has not happened. And it would be justified in certain circles. I mean, someone was saying the other day, Ms. Grootboom, who got the Constitutional Court to affirm her right to housing, died without getting a house. those are constitutional failures, and they can be only ascribed back to the Constitution as not delivering. So I was talking about that, just to contextualize.
Thank you very much, Judge. My last question, 7.1, Pillar 7.1, where you mentioned the need to ensure that there's a strong, accountable judiciary. And I've been thinking about this because how will you do it as the Chief Justice of the Republic of South Africa? How will you ensure that this accountability happens?
Thank you for the question again, Madam Speaker. We do have accountability measures as we speak in terms of the judiciary, annual Judiciary Day, where we tell the South African society what we've done in that annual period. But what worries me is it's one thing to tell the South African public that we've had so many matters, but it took so long for these matters to be finalized. We have so many judges that have received judgments for these long length of periods. We're telling them, but accountability says, what are you doing about it? And as Chief Justice, if I'm appointed, I've said there should be consequence management. There's no consequence management against judges who reserve judgments for very long periods. And that's another area that erodes confidence in the justice system. If you wait for a judgment for 2 years, when it comes, it's already academic in certain instances. So I'm talking about accountability to that extent, if I could give you that example. There are other examples I can cite.
Thank you very much, Judge President. Thank you, Acting President.
Thank you, Commissioner Mapisa Ngakula. Commissioner Malema.
Thank you very much, Deputy President, and good afternoon, JP.
Michelle, good afternoon.
I was very happy when you spoke about the court in Soweto. And Soweto has got a huge population, and that population is even bigger than many other neighboring countries. Shouldn't Soweto get a high court of its own, based in Soweto, to service that big constituency, which some of it is bigger than some of the countries next to us, as part of your plan to make judiciary accessible to our people, where people can just go and litigate in high court without getting a taxi or anything. They just walk there and they get matters listened to and attended to without spending too much money, which they don't have. Soweto has got as well a mixture of different classes of society, which litigate all the time. I mean, if we were to go to Johannesburg High Court, a lot of people you find there come from Soweto. And not only Soweto per se, you've got the suburbs as well on the south, which can also litigate in Soweto. Have we not reached a point where we must establish high courts in areas like that to deal with apartheid spatial planning? Because for us to resolve matters through the court, we must go into some wide establishment, because that's where courts are found, as part of making our people access. I'm giving Soweto as an example, as part of making people access justice.
It is, thank you for the question, Commissioner Malema. Yes, it is an access to justice gap that we continue to use apartheid infrastructure. As you say, the High Courts was planned to be in Johannesburg to service large areas or areas that have big concentrations of persons who are sued in the High Courts. So it would happen, and you would be interested to know that when I took over as JP, for about 2 years, I would send judges to go and sit in Soweto, to go and actually hear cases in Soweto. I did that, but I had to stop because the magistracy leadership says, JP, when we give judges space to work here, we're actually pinching ourselves because there's actually no space, right? So that point I agree with totally. But the issue is, there's a toing and froing in terms of finding land to build the magistrates court, you know. But if the land, I mean, the city of Johannesburg must have land that it can identify for this purpose. And it could combine to say you'll have the magistrates court there and the high court there. Because in other countries it's like that. You walk this way, that's the lower court, that's the magistrates court. You walk this way, that's the high court, in the same premises. So I agree with you.
On a different matter, JP, in line with transformation, shouldn't we bury our heads in shame that 30 years into democratic society, almost, we've never had a Chief Justice who's a female, or even a Deputy Chief Justice who's a female. And when we talk female, we talk exactly what the other commissioners spoke about. People who come with the necessary qualities, who have always been there since the dawn of democracy. Yet we have not found it in our own wisdom to appoint either a female Chief Justice or a female Deputy Justice. Shouldn't we bury our heads in shame as people who are proponent of judicial transformation?
Transformation is a journey, Commissioner Mlambo. It being a journey, sometimes some journeys are slower, and sometimes there are reasons why they are slower. Yes, we've not had a female Chief Justice or a Deputy Female Chief Justice. We've only had them at an acting level at some stage. I make that admission unreservedly. But as to whether we should bury our heads in shame, I'm not sure I can go to that extent. But I agree with you, yes, we should find a way of ensuring that we push transformation in line with the constitutional dictates.
When I say burying our heads in shame, I mean, can we, like now in a public platform, declare that we are not proud of that? It's a regrettable development, taking into consideration what you are saying, that it is slow. I don't know why it makes it slow when it comes to women. It didn't become slow when it came to African men, because we know we come from a white-dominated society, but men just came in, it was not slow for them and all of that. So burying our heads in shame, I simply mean we are at a point where we must not be very proud that we are almost 30 years into democracy and we've never produced neither a Chief Justice who's a female and a Deputy Chief. It's not a matter we can be proud of.
The question is, should we make a declaration that we have failed? I don't understand the question.
We were failed, and if we don't want to go there, we're not proud of this account, that as leadership of the judiciary and as the commission and as proponents of transformation in the judiciary, we cannot sit here and be proud that almost 30 years into democracy we have never produced a CJ or DCJ who is a female.
As I said earlier, the journey has been slow in terms of achieving that particular milestone. Kenya has a female Chief Justice for the first time, but it took them more than double the time we've had since our democracy. dawning to have a female Chief Justice. So these journeys are slow. I'll give you that answer.
So appointing you with all the qualities that we have, which I do not question, and I agree that you are one of the fine brains our country has produced. So appointing you as a Chief Justice, in terms of transformation, which box are we going to be ticking and say your appointment is an advancement of transformation in the judicial?
Well, my answer is we all bring different qualities to this body. And it is those qualities that must be looked at to find a candidate who is relevant and suitable at this time to be the Chief Justice. And that's why the President has shortlisted 4 of us. So I'm saying I am a candidate. I bring my own expertise. I'm a judge, a head of court in my own standing. Like President Maya says, don't look at her as a woman, but look at her as a judge, as a head of court. Look at me, I bring my qualities, and I'm saying, I have advanced transformation, especially gender transformation in what I do. I've shared statistics about the efforts I've made at bringing and appointing more women to the bench. The question should be, in all those qualities and our transformational thinking about how things can be done, who is best suited at this time to be appointed Chief Justice to continue on that transformative journey? And that's the answer I will give you.
JP, unfortunately, you're not giving me an answer, you're giving me a question, because in your concluding statement you said the question should be, and that's not an answer. Me and you, we sit in this body and we fight a lot with a lot of people, including heads of courts, about ticking boxes in the transformation. I agree, you've got all types of qualities that no one can dispute. But I'm asking you to help me so that when I go into the deliberations and eventually you are appointed, we can stand proud and say, in terms of this form of transformation, the appointment of JP Mlambo ticks this box. And that's how we came to in line with transformation, not the qualities, the expertise that you bring. That I agree, I'm going to consider that in the debate, but as a person and a proponent of transformation, I want to be persuaded in terms of transformation agenda as to, in the support of your appointment, which agenda in the context of transformation will I be pushing? Which box am I ticking when I say, here is JP Mlambo, the new Chief Justice of South Africa, appointed and is going to advance, or his appointment is an advancement of transformation? Will your appointment tick any box in the form of transformation?
The President will make that call if my appointment ticks the box. I think, Commissioner Malema, the issue is whether, in terms of ticking boxes, whether the qualities that I bring, the experience that I bring at this time of the South African judiciary, whether it is the right mix that is required for a leader of the judiciary. That's my answer. I can't take it further than that.
Yeah, but then it means we must leave, because you said the President will make a call. And we are sitting here asked by the President to come and help him to choose the best, and we're being excluded in that process, that the President will make that call if I'm making the right transformation appointment. I'm just saying, JP, I'm going to argue that in your answer to this question, then you exclude us and say, no, leave it to the president. When we also have a duty to recommend to the president a proper, suitable candidate who tick all boxes, including the box on transformation. On the separate issue,
Could I respond to that?
So no problem, sir.
Thank you. Commissioner Malema, I'm not excluding anyone. The president nominated me to be interviewed for the position of Chief Justice. That is not a simple thing. His expectation of the JSC is to look at the 4 persons he has nominated, and for the JSC to tell him that in our view, we have looked at these things, at all these qualities. We have looked at the current context where we find ourselves. We have looked at whether all the boxes will be ticked, transformation and everything. We know that this one has done this, has got this. In our view, this is what we think, having interviewed these candidates. So I'm not excluding you. It is correct. The president will make the call at the end of the day, but he has consulted the JSC to assist him in that process. So I'm not excluding the JSC.
JP, you have done very well with regard to case management and making sure judgments are being made and delivered on time, and judges are being held accountable when there are such delays. In where I come from, in the EFF, there is what we call 7 non-negotiable cardinal pillars. So when you said 7 pillars, I was like, hey, what's happening now? So I didn't hear you taking us through about what you are going to lead in the immediate, which is the Constitutional Court. What are you going to do at the Constitutional Court? 1, 2. What are you going to do to make sure that the Constitutional Court delivers judgments on time?
Yes.
Because the way they deal with cases there is completely different from how you deal with them at the High Court. You've got so many judges sitting on one matter, and they must all be making those, inputs and all of that, and colleagues asking for extensions, and as a result, the matters just get delayed, and we never get to actually get judgments on time. So I want to know, what are you going to do to make sure that Constitutional Court delivers judgments on time? There was a matter that it was so embarrassing of that review that Dali did on Zuma's case in the Constitutional Court. What do you call it?
The rescission application.
Rescission application. JP, the country got so excited. Lawyers were told Friday, submit this on Sunday, and then by Monday the matter was heard. So everything had to be done within 2-3 days because it was done by other people. When now the court had the matter and was supposed to deliver judgment the same way they were making people run, the court just took forever. And the country was burning, and we thought that judgment was going to help us, resolve the problems we're confronted with as a country. The matter by its own nature was extremely urgent, which would have required ordinarily judges not sleeping because there is this issue that the country is confronted with. Even with that practical evidence, like you said, you listen to radios, you can see. No, it took forever to be delivered. What are you going to do as a new Chief Justice to make sure that the Constitutional Court delivers judgments on time? And what is it that need to be fixed to make sure that also the Constitutional Court delivers judgments on time?
Thank you, Commissioner Malema. Let me start by saying, in my 7 pillars, when I dealt with pillar number 4, I mentioned that the way the Constitutional Court works has to be looked at. I didn't go into detail, but it's there. And now that you've asked me the question, I worked for 5 years at the SCA, and I want to use that example. The Supreme Court of Appeal, when you go home on recess, you go with your boots full of records. So that when you come to the term, you are ready to run and hear matters. And when that term ends, you must have written all the judgments emanating from the hearings of that term. I think that's best example, that's best practice, a best practice example that I can cite. And there's a reason how the SAA does that. When you go home, you know which matters have been allocated to you to scribe. It's like that in the Constitutional Court. And when you hear a matter, after you've heard the matter in the SAA, all of you go to the presiding judge's chambers to debate the outcome of the matter, how you see the case in terms of the facts and the law. You debate it, at the end of which, if there's a unanimous agreement about we're going that way, a scribe goes and writes in line with that. And if there's a dissent, the dissent, he will wait for the majority judgment to come, but it doesn't mean he'll wait and do nothing, because he has heard the views, right? So that when the majority judgment is circulated, he will see if he still wants to dissent or whether he has become persuaded. But that process is not allowed to delay the handing down or delivery of the judgment. In the Constitutional Court, I'm told, I've not presided, I was supposed to be in court today, but I'm in court here. But I'm told that the issue of retiring to the senior judge's chamber or the most senior preside doesn't happen. You must write a post-hearing memo to all the colleagues, say this is how I've seen it. And then you'll pardon me because this is what I've heard when I asked, how do you guys come to judgments? My view is that this in itself will result in delays. Post-hearing memo, then there's a debate on email, everything, then there's a conference held probably a week or so or 2 weeks after the hearing. Then there's debate, then there's a view, say, okay, I agree with the direction, but I don't agree with this reasoning and whatever. And then you find that separate concurring judgments start germinating. When the next time you look, from the date the matter was heard, it's easy for 2 months to have come and gone without any realistic prospect of a full judgment seeing the light of day in the next month or so. That's what I think. Just President Salaries said there, he finished last week. He can correct me where I'm wrong. But as I'm sitting here, I see emails where judges express views about drafts that are still doing the rounds. And you can check when those matters were heard. So I think as Chief Justice, it calls for a necessary discussion as to whether all these roundabout ways of ensuring that the judgment is quality cannot be short-circuited. I think that's one thing that I will engage colleagues to say, guys, this is not on. Let's see how we can do better in this regard. And talking about an urgent matter, you know, we run divisions where we've got an urgent role. A judge who hears an urgent matter knows that a judgment must come out within a week, under all circumstances. And he would have had the average number of matters in the urgent court in Gauteng is about 60 a week. That's a lot, but we still try. Some of them take longer than a week, but we understand the matter is urgent. It needs to be dealt with. I can't compare the High Court and the Constitutional Court, but I'm just saying a serious rethink of how they approach judgment writing in that court has to be undertaken to ensure that there's remedial action taken.
I'm rushing my 10 minutes. I wanted to canvass that point, but let me go to a different point. See, former CJ, Mokhwe once said, we shouldn't reach a point where when matters are sent to that court and they are sent to so and so, we already know where the direction the matter will go. have we not reached that point with Pretoria High Court where we already know if this one goes there, the judgment is going to go the other way? Perception is everything in the judiciary, and that's a perception held in a lot of quarters that once the regime goes to Pretoria, or you take the regime to court in Pretoria, you are guaranteed the establishment is going to win. And this I couple with this research that was presented to other candidates, that people have lost, people are losing confidence in the judiciary. And one of those things that makes people lose confidence in the judiciary is the obvious outcome that we know if these ones go there, they are going to win, is given. What are we going to do to change that? Especially when you are leaving a division with such a perception and going to assume a much more bigger responsibility. What plans are there in place? I'm not talking rumor, I'm talking perception. Yes, where people just like, Pretoria. Some of us even know that if we win in Pretoria, we jump like school kids because we've already concluded we won't come back alive. So what do we do to deal with such a perception, JP?
Thank you for the question. I think, let me start by saying it's unfortunate that such a perception is doing the rounds, that the Gauteng division in Pretoria is executive-minded. It is not executive-minded. The cases that come to us with particular facts dictate to us as judges how we rule on those matters. It is unfortunate that people think if you go there, you are going to go this way. You said it yourself, if we win, we jump like school kids. So it doesn't mean you lose everything, does it? It doesn't mean that. So it is unfortunate that such a perception is there. It is an unfounded perception. It's a question of educating the public in understanding. Like the exercise I went through this morning in explaining the state capture judgment and the CR17 judgment. If you bed down those facts to their bare essentials, we didn't flip-flop. So it is unfortunate that people think that it's not like that. And in any way, it's not only in Pretoria that such results are found, even in Joburg, even in other divisions, you know. So you can't say that if, say, the case of former President Zuma comes to the Western Cape High Court, he will win. But if he goes to Pretoria, he will lose. You can never say that, because it's not like that.
That's the impression I have, that if he goes to Western Cape, he's likely to win.
Which one did he win? Can you tell me one that he won there?
The last question, JP,
yes.
Before the acting Chief Justice called a press conference to respond to a political statement, yes, or a political article.
Yes.
Do you encourage that? Don't you think that descending into the arena compromises the judiciary? Because I come from a school of thought that suggests such articles, ministers who are responsible for judiciary are better placed to venture into that space. That's why there is a political head, if you want to say so,
yes,
who looks after the judiciary and accounts for its activities politically and otherwise,
yes,
in a form of a minister. Now, when we've got judges coming to debate political issues that are raised by politicians, and also critiquing the constitution and the performance of our courts and the judges and all of that, do you think it was a wise move for acting Chief Justice to do so? And in the same spirit, the acting Chief Justice says he consulted before he did a press conference. That's what he said in the press conference. I want to know if you were consulted And if you were consulted, what was your view before he went to the press conference?
Thank you, Commissioner Malema. It is correct. We were consulted as heads of courts, and we were given the full text of the article written by the minister. And in consulting us, the acting Chief Justice said he is minded to issue a statement to rebut the allegations made against the judiciary. And he invited us, those of us who were so minded, to provide him with content that he would put in the media statement that he would issue. I'm one of those heads of courts who responded and say, we agree that you can issue. I agree you can issue a media statement. And I also suggested some part of what he could say in the media statement. It was his decision, the acting Chief Justice, to decide to, instead of issuing a statement, he'll hold a live media briefing. It was his. And I want to suggest to you, Commissioner Malema, that there comes a time when you are a leader of an institution when you must take a decision, and you take a decision whatever form it comes. He took that decision, and I cannot fault him if that's what you want from me. If I would have done that, that's a different question, because it's happened. But I'm with him all the way in taking the decision to do what he did. And by the way, it's not the first time that it happened. You will recall that a few years ago, when a lot of statements were being issued by faceless people that judges were paid 200,000, 300,000, whatever, Chief Justice Mogoeng convened a media briefing and addressed the media about that issue. So there comes a time, sometimes, when a head of court or the head of the judiciary finds it necessary to take such action. So that's my response. Thank you.
So when appointed as CJ, we are likely to see you in press conferences exchanging with politicians.
I said, in answer to the question, whether I would have done it the same way is a different story.
No, I'm now putting it to you.
Not necessarily, no. We have a communications policy. Yeah, I'm sorry, I think you are still asking me.
No, I'm done. I'm with you, JP.
We have a communications policy in the Office of the Chief Justice and the judiciary. I chair that committee. And it is clear that whenever there were issues that arise, say about a particular court, we source, the spokesperson contacts the head of that court and sources the response and then provides a response. Mostly it's media statements. So it is during the Matojane saga, when a lot of things were saying, he, as Judge Matojane, wanted and implored me to say, issue a statement or call a media briefing. I discussed it with the acting Chief Justice, and we agreed that no, we'll be giving oxygen to this thing. Let's not do that. It will die down. And we persuaded him. So I'm saying I will make a judgment call depending on what comes out. And by the way, our consultation by the acting Chief Justice was about that part that I also felt was offensive to us as the leadership of the judiciary, to be labeled house niggers, spittle of the master classes, you name it, colonized minds. That's not criticism. It goes far deeper than criticism. It's offensive. And that's why I say I'm with the acting Chief Justice in the decision he took.
Now the last question, is, are judges allowed, and if they are, how does that help enhance the good image of the judiciary, for judges to visit politicians in their houses? And when that matter is exposed to the public, and judges are asked, what were you doing in a politician's house? And a judge says, we're discussing a matter of national importance. Not readily available to divulge what were you doing in a politician's house, which suggests that a judge might be having some secrets with a politician, which is different when you go and meet the minister of whatever to discuss the issues of maintenance of courts and all that. When you are asked, you say, no, I met the Minister of Public Works. We're discussing maintenance of courts because Polokwane Court is collapsing and Mpumalanga Court is collapsing, so I saw the need to meet them. The same way you said, voluntarily, yeah, I've met Standard Bank because I don't know if it was my place or not, but I felt I needed to engage them on their briefing patterns. If someone comes and say, you met the CEO of Standard Bank, what were you doing with them? You are able to say, I met them because their briefing patterns got me worried, but I realized it's not something I should continue with it. That's being transparent and open. Now you are told as a judge, you went to meet a politician in his house, please confirm, you confirm, what were you discussing? No, it's a matter of national importance. Leaving the nation to speculate, and when we start speculating and making those unfounded allegations, you come back and say the judiciary is being attacked. You think it's an acceptable thing for judges to be visiting politicians and having some confidential discussions with politicians which cannot be shared with the public?
No, I don't agree with that. In my book, that is not on. It should not happen. And it's some of the issues which we discuss in judges' meetings. I can tell you, Commissioner Malema, that I have had judges approach me to say, I've been approached by this person. He says he's sent by that minister to say they want to meet with me. To discuss what? Well, to conscientize me about how we should rule in matters. And I said, you don't touch that space. You don't touch that space. So if a call comes to me to say, I would like to meet you, say from a minister, I say, okay, explain to me, what are we discussing? If it's an agenda that I don't have a problem with, I say, where are we meeting? Is it appropriate that we meet there? Why don't we meet there? Right? And so that when you are asked, why did you meet this minister? You say, we met to discuss the following things. To say there's a matter of national importance without disclosing what it is makes it even worse. So in my book, I don't agree with that.
Thank you very much, JP. Thank you, Acting President.
Thank you, Commissioner Malema.
Follow up.
JP Salaries was the one to first indicate, Minister, if you would bear with me. Thank you.
Me too, follow up.
Thank you, Acting President. JP, I'm sorry, I'll just take you back. I didn't want to disrupt Commissioner Malema's trail of thought by following up on this aspect. You touched on something that I believe is quite important, which is Section 174, subsection 3, where you say the President is consulting this body. Now, I want your view, given the experience you have and that you've been serving on this body, on what is the President expecting from this body through this process. I mean, it's for the first time, to start with, that this process takes place and we've got more than one candidate. And if I may remind you of Section 174, subsection 3 of the Constitution, which says, the President as head of the National Executive, after consulting the Judicial Service Commission and the leaders of parties represented in the National Assembly, appoint the Chief Justice and the Deputy Chief Justice. I will end there. The rest refers to the Supreme Court of Appeal. Now, what I want to understand is, are we expected to interview all 4 candidates and say to the President, we have consulted, we have interviewed them, they meet the requirements for consideration for appointment? Or is our function, perhaps if I put it bluntly, to eliminate some of them and say we give you only 2 or 3 names? What is your understanding of this process? Thank you.
Thank you, Judge President Lalete. I think the first aspect that has to be considered is the issue of suitability. are the candidates that we've interviewed suitable? And this body, which is being consulted by the President, will have to express views on that, on suitability of each candidate. And then the next one is on appointability. Nothing prevents this body from either saying we're not going to comment on appointability, although I think it would be shaking its responsibility if it says we're not going to say anything about appointability. I think this body, and this is my own view, this body needs to look at each one of us. What this body has found ticks us off or ticks us on, and to express a view on each of our candidatures to the President, right? And then to say, we think they are all appointable. We found that this one has got this strength, he is eminently appointable. This, I think, is what the job of this body is. And then let the President then take the final call as to, having considered, looked at what you have sussed out of all of us, whether he's persuaded on one candidate or on another candidate. And that's it. I would say that would be my take about what this body should do.
So your understanding is that the President has not delegated his power to appoint to this body, but merely to consult and say, tell me your views on this candidate.
Definitely. He has not said recommend either in line of preference as far as you are concerned or whatever. He's just saying, tell me what your impressions are of these candidates to help me come to a final decision. It is his decision to appoint.
I see. Thank you, JP. Thank you, Team
Follow up, President.
I don't think that it is appropriate to solicit the opinion of a candidate on how we should deal with this, even more so when we have not given the other two candidates an opportunity.
Is that the ruling, Chair?
It is.
Let them respect it.
And it won't be dealt with in the deliberations.
Honorable Minister, did you want to weigh on this?
No.
Okay, thank you.
I respect your ruling, Chairperson.
Thank you. No, I would have informed you that if you wanted to weigh in on it, I'd already made a ruling, so I would have allowed you to
I don't
do
want
so.
to be thrown out.
Thank
you. Mine is in relation to the access to justice question on the Soweto matter that Commissioner Malema raised there, JP. I just want to get your view. You are aware that there is this process that we have appointed the former Deputy Chief Justice to help us with the issue of the rationalizations of the court and also this issue of the spatial planning. And it came out as a result of many complaints that we are receiving on that, and it's a project that has not been done since 1994 to really deal with the judicial establishment and the excesses and where exactly it should be. And we also receive lots of complaints, for example, on people within the area of your jurisdiction, but they are outside. The people of Mabopane, they raise issues that they can only go to the Northwest High Court when they are just 2 minutes from Gauteng. So my question is, how do you think while we're dealing with that process, can the rules be used to help us to maybe even, or yourselves, to allow litigants to institute cases in the circuit courts where they are, where there could be circuit courts and so forth? And even in the Eastern Cape, I think we have the same kind of problem where people from East London have to jump Bishop and go to, I think it's Grahamstown, if I'm not mistaken. You'll correct me, you might not have the experience, but something like that, where the former Bantustan's arrangements are still within the boundaries of our courts.
You are correct, Minister. Those boundaries still persist to this day. And I think you sit here, you had the justice portfolio. You lead that portfolio. I think it's something that needs to be seriously factored into. When I was chair of Legal Aid South Africa and found that East London, Bishop, Grahamstown dynamic, I was shocked. So, but in this day and age, why are things still happening this way? They shouldn't. That's my view. If that's what you want to hear, that's my view. They shouldn't. When this Mabopane issue arose, we had been consulted as a judicial, and we cautioned the executive team that you're going to be causing problems. If someone who lives in Mabopane can get into a taxi and travel for 20 minutes into the Pretoria High Court, and you expect that person to say, now he needs to get into a taxi where he travels for 3 or 4 hours to access justice, it does not make sense. It can be addressed through the usage of circuit courts. You know the labor court scenario, Minister? When the 2 high courts were being built, in consultation with the JP of the labor court, we said, people in Polokwane, in Thohoyandou, with their labor matters have to come to Johannesburg. That's not all. They should be given space in this new court that's coming up to bring access closer to them. Same with Mpumalanga. So what I'm saying, Minister, is we need to seriously overhaul completely these apartheid boundaries that we still subscribe to. And should you appoint me as Chief Justice, I'll ensure that we bring to the table necessary evidence and input that will assist in refining, reforming, and redrawing these jurisdictional boundaries. Because it's not on. People actually resort to getting addresses within Gauteng. She knows I'm in Northwest here. And I know someone who's in Gauteng. And they use that address to actually found the jurisdiction of the Gauteng division. You can't make people resort to those measures to access justice.
Yeah, maybe it's to ask whether, as the head of court in Gauteng, are you making such inputs to that process of the former Deputy Chief Justice? Because we are hoping that he will advise us comprehensively. As you can see, some of them I can't remember in terms of the boundaries, but I have learned in these 2 years that there is a lot of such challenges.
Yes. Well, we've not been contacted as heads of courts. We're actually talking about it. And when I left the division, I warned the 2 DJPs to be on the lookout for an invite to go and make input. We are ready. And I think my understanding was that it was going to also look at the adequate or appropriate capacitation, the judicial establishments of those judges. So as far as Gauteng is concerned, I can say we're ready. So immediately the DCJ and his team contacts Gauteng, I think he'll get the necessary input.
No, thank you. I think he will. Thank you, Acting President.
Thank you, Honorable Minister. Commissioner Singh.
At last. Thank you very much, Acting President, after many follow-ups. And I hope I'm not the one who will say lastly and I last for 20 minutes.
So, tell the Deputy President, I think you forgot me.
Okay.
I think you forgot my fellow.
I beg your pardon, Commissioner Madonsela. Yes.
And sorry.
My apologies, Commissioner Singh. Instead of a follow-up, you have an interruption and a delay of whatever questions you wish to put to Judge President Mlambo.
Yes, just one question. Good afternoon again, President Mlambo.
Good afternoon, Commissioner Madonsela.
What are we to make of the fact that you are making yourself available to be the first amongst equal in the Constitutional Court, a court that you have not as yet sat on and acted in as a judge until now?
Nothing turns on that. Nothing turns on that. The fact that I've not acted there does not denigrate, if I may use that term, my candidature. I'm an experienced head of court. I've been in different environments. I can hit the ground running anyway. And I've given you a vision that has 7 pillars. That is exhaustive as to what, as head of court, I would regard as things I should look at as head of the judiciary.
The reason I asked the question is because in response to Commissioner Malema, I did not, what Commissioner Malema asked you, and it was of interest to me, is what are you going to do in order to deal with the problems in the court, in the Constitutional Court, relating to delays in judgments?
Yes. And
I did not understand you to be answering that question directly, except that you did mention that you told us about what happens in the SAA and how those problems are resolved. But having not been in the Constitutional Court itself and understanding the challenges of that court, how can it be that you can offer a solution in relation to the problem you are not aware of?
Well, I think I answered that question. I explained to Commissioner Malema what my impressions are about how they deal with judgments in the Constitutional Court. And I did mention that, you know, as head of court, my leadership style is not to impose solutions. It's a consultative process where there's buy-in, everyone, to say, colleagues, there's an issue about the delay we are taking in delivering judgments. What is it that's causing the delay? And together we identify those issues, and then we say, what is the corrective action? With a view that the corrective action will eliminate the issues that cause the delays in terms of judgments being handed down. So I answered that question fully.
Yes, I entirely agree with you, Judge President Mlambo. Thank you. Commissioner Singh.
Thank you, Acting President. I think it'll be appropriate for me to say good evening, JP Mlambo, because it's 6 o'clock already.
Good evening, Commissioner Singh.
Firstly, thank you very much for presenting your 7 pillars this morning, and not only presenting them as problems, but solutions. They were solution-oriented, and I think that's a good thing, that somebody can come up with solutions to the problems that they see within the judiciary. And I think one of the cornerstones of your pillars was the lack of resources being an impediment, whether they're financial or human resources. And you spoke about maintenance issues, and sometimes from my own experiences, maintenance issues, you know, border from the sublime to the ridiculous.
Yes.
From roofs needing repair to judicial officers being asked to bring their own toilet paper.
Yes.
And it's happened in a regional court, you know, in the area where I come from. But having said that, we've gone through the State Capture Commission, and 2 of the reports have been already handed to the President. And there are a number of recommendations, and many of them would require the courts and the prosecutorial authorities to act, because we can't allow this just to be a soap opera. Never-ending soap opera. In soap operas, you find that, yes, there's always a happy ending. People live happily ever after. But here, we're not going to find that. And I'm linking this to resources. And earlier on, you spoke about interns and resources being sought from outside sources. Do you think, if you are Chief Justice, you would recommend that if we as a country can get resources from outside, from anybody that's committed to ensuring that's judicial independence, and we have an effective judiciary, and we try these matters as soon as possible, would you be adverse to that kind of suggestion, and that we get outside resources to beef up capacity within the NPA and within the judiciary to deal with these matters as expeditiously as possible?
Let me answer the question this way, Commissioner Singh. I think we have a document that I think former Chief Justice Langa was part of. I think it's the Bungalow Principles, if I'm not mistaken. It's a document that provides guidelines about how the judiciary should behave. And it touches on private funding aspects. Its point of departure is that it should not happen. That's its point of departure. But I think it also says, I've not read it for some time, but I think it says if there are instances where it has to happen, and I've done it, I'll tell this commission, I've done it, care should be taken that the judiciary should not be compromised or be seen to be compromised by having accepted such financial assistance from such an outside entity, right? So I'm saying it's an issue that, say, affecting the courts, to say you need, talking about the judiciary, it's a question of sourcing or having more judicial officers to sit in these matters. You can't sort judicial officers from outside. It's a question of sourcing them from here. So it could be a question of, say, the resources that you have in terms of the interns or the prosecutors. So we've got a prosecution agency. It will decide whether it has the capacity, and if it doesn't have it. So I think we will have to identify the scope within which we think we need outside assistance. And from what you tell me, I'm not sure that there's a good case to be made out to look for funds outside, because Treasury is here and properly motivated and properly identified the areas where added capacitation is needed. I'm sure we can deal with that issue without going outside, because remember, Commissioner Singh, we're dealing with state capture that tells us that this country has experienced malfeasance of magnifying or of certain magnitudes of malfeasance. In certain instances, outsiders are alleged to have been complicit in this malfeasance. So I think extra care has to be taken, whether we go out and look for money to actually start carrying out the recommendations of the State Capture Commission report. So I would voice that caution, Commissioner Singh.
But you're not adverse to it. However, we have Honorable Speaker and Minister here. I think we're hearing us loud and clear, because South Africans deserve, to get answers, and they deserve to see people being prosecuted for all this malfeasance that you speak about.
Yes.
My second question, Honorable JP, is you could in April be sitting there chairing this JSC, because we have a session in April. Today, as Honorable Lucas said, you're on the other side answering questions, and it's not court. Now, whilst I respect the ruling of the chair on the issue of the sexual harassment and how we deal with it, and it should be expunged from the record, I put it to you that thousands of viewers of television and listeners on the radio have already been exposed to what has happened for about 2 hours. And having said that, we may expunge it from the written records. Do you think that if you are chairing this session, or even as a member of this JSC, which you will become in April, that we should not have a serious in-camera discussion as a JSC on how we approach these matters of founded or unfounded allegations? Because this is not the first and the last, it's going to happen. What would your suggestion be if you are sitting on the chair on how we approach these matters of allegations?
Thank you, Commissioner Singh. You will recall that in April, this issue was discussed by this commission to say, what do we do when we get, you remember we dealt with the complaints against Judge Langa at that stage, to say there are people who have complaints that they can lodge to the regulatory bodies that deal with particular candidates who come here, but they don't lodge anything. They wait until there's a JSC process, then they send the objection here. I don't know if you remember that discussion, to say we need to establish a small committee here that comes out with rules about how we deal with these aspects and other aspects. You are correct. I think this body needs to do a serious rethink as to how it deals with the material that comes here.
No, thank you. The other question will relate to your questionnaire. I mean, when we read your questionnaire, we find strong administrative skills, and knowing the way you run your current court, we can see that. And I think you spoke a lot about case line management and modernization, which is something that we must aspire to sooner rather than later. Now, I believe that you convened the Justice and Administration Information Technology Committee. And I would just like to know, what are your views on the cyber attacks on the court system in October? How do we marry those attacks with the online system, electronic system? What solutions can you prefer to ensure that the online system is secure and that there can be no interference?
Well, it's a question that the IT geeks will tell you, that security and more security and more security, because that's what we need. When the Office of the Chief Justice system was hit in 2018, and it happened on my birthday, I think, on the 18th of September, that's when it hit. And it's a question, as Jade, who said, you must tell us what was the security arrangements in place, right? Because some of these cyber attacks are opportunistic. If they find the environment impenetrable, they look elsewhere. So my short answer is, we need to always be secure. The case lines has never been hacked. It's unhackable, let me put it that way. But there's a reason it's like that. So in all our platforms, online platforms, we need to ensure that we have the best security systems that prevent these cyber attacks. Because, you know, Commissioner Singh, no security system is foolproof. Let me tell you that. These cyber geeks who sit somewhere in the dark space, they are always researching how best to penetrate whatever systems are there. They are hitting banks, you know. So all I can say is we need to ensure that we beef up our security and we review this security on an ongoing basis to make sure that when some new techniques come on the market, we also beef up our security in line with it. That's all I can say.
And lastly, and that will be the last one, Acting President. I think Commissioner Malema and others spoke about restoring confidence in the judiciary, and the Afrobarometer survey shows that people are not happy about the way the judiciary in general is performing, for various reasons, you know, delayed judgments, the high cost of going to courts, etc. But as a layman, I just want to know, and you're a jurist of long standing, in the recent President Zuma matter of contempt, it was referred directly to the Constitutional Court. Is that a normal thing to happen, that a matter of contempt goes right to the apex court of the land? What is your view? And I know hindsight is the best side.
Yeah.
And I know you would not want to speak against, in your parlance, brothers and sisters. But I just, as a layman, want to know, you know, what prompted that to happen.
Before the Constitutional Court hears any matter, Commissioner Singh, the first test that it looks at is whether the matter triggers a constitutional issue, right? The second issue is, if it doesn't trigger a constitutional issue, is whether it raises an arguable point of law of general public importance. That's the test. Once that test has been satisfied, when it comes to issues of direct access, the court loathes being the court of first and last instance because it has acknowledged it can benefit from the views of other courts in some of these matters. Now, you mention a contempt of court issue. Ordinarily, I want you to hear me, that matter shouldn't be a matter of first and last instance, ordinarily. But what happened was, there was an application by the Secretary of the Commission to the Constitutional Court. President Zuma, against whom the application was directed, chose not to oppose that matter. You'll recall that. The Constitutional Court was at pains to say, does this matter trigger our constitutional jurisprudence? Yes. Having done that, are there exceptional circumstances that we as a court can find that we can use to say, yes, we must hear this matter? And the Constitutional Court went through that exercise and found that there were. It was highly critical of how the Commission had dealt with the matter at certain stages, but it found that despite that criticism, it still thought that there were exceptional circumstances that it could use to say, yes, we can hear this matter as a matter of direct access. So I've answered your question in the sense that, is it normal? It's not normal. It takes some seriously abnormal, exceptional circumstances for the court to do that. It has done that in a number of cases, but very sparingly.
Thank you very much. I'm sure your response will trigger many more questions as follow-up. Thank you very much, Acting President. My 10 minutes is up.
Acting President.
Thank you, Commissioner Singh.
Acting
You shouldn't have invited follow-ups to the questions that you posed to Judge President Mlambo.
Just follow up, not on that issue.
Yes, Commissioner Mbofu.
Thank you. Yes, no, I can't make a follow-up on that issue. Justice Tlaleti and myself can't talk about it. Because he was on the bench and I was arguing. Just on a separate note, a good evening, JP.
Good evening, Commissioner Mbofu.
Yes. No, I just wanted to, one of the questions from Commissioner Singh related to a matter that the Chair has made a ruling on, which we all respect, and I can assure you it will be raised at a different forum. But I just want to ask you, if you go to page 12 of the small book of the questionnaire that all candidates had to fill.
My questionnaire?
Yes, yours.
Yes, I've got it.
Commissioner Mbofu,
yes.
We're waiting for you to
Oh, I'm sorry. Did you say yes? So
yes,
I thought you were still
President.
finding it. I'm sorry. Did you find it?
You said section 12?
No, page 12.
Yes, I'm on page 12.
Page 12, paginated page 12.
Yes.
Yeah. Yes, there's a question there. I just want to be sure so that if it arises, I can deal with it. Question 19 that was asked to all the candidates. It says, are there any circumstances known to you which may cause you embarrassment in seeking the appointment for which you have been nominated? And the answer there is no. Do you stand by that answer?
Yes, I stand by it.
Thank you.
Commissioner.
Chair, I don't know how we're going to enter it, Chair, because my worry is that if we ask it the way Commissioner Mbofu does, and JP responds this way, then we're going to have a problem, because the JP in his answer, unless your ruling is that even on the other side it won't be raised. Because if it's going to be raised the way Commissioner Mbofu is going about it, then the argument is going to be that the JP in his response said there is a former judge who raised this matter with him. And when this matter was raised by the former judge, why was it not put in that questionnaire? Because it is now brought to his attention. So I don't know. Well, I'm happy to leave it. I'm not big on it.
Would it not be best perhaps to deal with that at an appropriate stage?
Fine, Chair.
Thank you.
I agree, Acting
Commissioner Dodov.
All right, thank you very much, DP. Good evening, Justice Mlambo.
Good evening, Commissioner Dodov.
You must be tired by now after this long grilling. Are you okay?
I'm okay.
All right, thank you very much. Firstly, I must express this disclaimer that I know Justice Mlambo about 10 years now. And very interestingly, when I met him, he was a presiding judge, I was an accused. And when he came to the court, I saw a person who was very decisive, very firm, who wanted things to happen because he wanted to fast track the case itself. And having read your profile here, the work that you've done, it clearly shows that you are that kind of a person, and even the leadership that you have exercised in different positions that you held, it clearly demonstrates that what underpins your conviction is to get things done, and thank you very much for that. I must say this because I've said this to all the candidates who appeared before us. Now, as you are aware, this position you have applied for is a leadership position. What are your key leadership principles that drives you to achieve what you have achieved in the positions that you have held in the past, including of the judge president?
I think to embrace it all is, I believe as a leader, I take everyone along with me. Mr. Bonang Mohale has written a book saying, "Lift as you rise," which says, as you rise in your leadership steps, don't rise and leave the grassroots, rise with them. Because that's how you get buy-in in whatever leadership initiatives and interventions you take. So I believe in a consultative leadership, accessibility, engaging, as well as decisiveness.
Yes, and those who taught us are saying that a Chief Justice, which is the highest position in the land in the context of South Africa, that person who must be appointed or hold that office must possess a modicum of Solomonic wisdom. Do you think that you have that to ensure that if you are appointed, you can take this division or this apex court to the levels that you articulated in your 7 pillars?
I think my experience as a leader in various portfolios has equipped me. I've learned I'm experienced in institution building initiatives, in ensuring that institutions are stabilized and strengthened and become effective. So I want to believe that my experience stands me in good stead to ascend to this position, should it be the view that I go there.
Now, in one of the 7 pillars you articulated, you said you want to finalize matters expeditiously. Now, I want to bring to your attention a matter here of CC 147/2016. This matter, just to sketch a background because you don't have any information, it's about the murder of Wandile Bozwana. It started in 2016. 6 years down the line, the matter is not yet finalized, and one of your pillars is to ensure that you finalize matters. In this instance, what could be the blockages, what could be the constraints which impede a case of this nature? Because this is a high-profile nature, and the country wants to know what has happened, and 6 years down the line, it is not yet finalized.
Talking from the top of my head, I've not looked at it recently, is that, in fact, I'm not sure whether that matter has reached trial stage, whether it has started.
It has started, to just fill you in.
Yes.
The state concluded its case.
Yes.
Those accused applied for Section 174
Yes.
to be acquitted. They were rejected, and that they need to take a stand. That is where it is.
Yes.
I'm raising this matter because it is dragging,
Yes.
and it is in the interest of justice,
Yes.
and in the interest of the families affected, even the accused themselves, that this matter must be finalized. And my point is, and it's a principal point,
Yes.
the point is, it is 6 years down the line, the matter is still stuck.
Yes. I don't think it's the only one. There's also the matter of Barnard versus Porritt. Now, you do have these matters. It's not a general trend, let me put it that way. And I take it as head of the court that perhaps the matter could be expedited, right? I will have to go and check why it has been slowed down. Fortunately, the Porritt matter, I'm aware that it took a lot of turns to the Constitutional Court, to other courts, to resolve certain points until it reached trial stage. Even when it reached trial stage, a lot of shenanigans were entered into to make sure that it's delayed. So I take the point that it's happening on my watch in Gauteng, it's being delayed. I don't know what the circumstances are. Yes, it's one instance that you cite where expeditious finalization of a case has not happened.
Thank you very much. The last point, and I want to take you back to this issue of the legal aid board. And it is quite clear, it's apparent that in the 17 years that you served as a leader of the legal aid boards, you make great strides in improving the situation. Your contribution is immense and immeasurable in that sense, and even how you explain the work that you did. But there's a matter for me, and that matter is the fact that, and there's a perception that people have about the legal aid board lawyers, that they don't have confidence in them. They rather, in some instances, represent themselves, not the legal aid lawyers. Do you think that there is a need for adequate training for lawyers who are from the legal aid board, so that that confidence that people must have to the justice system must always be there?
I'm actually surprised that such a perception exists, because it's a perception that existed in my early stages of chairing the legal aid board. And we had to adopt particular strategies as to how we deal with it. The issue of employing experienced legal practitioners is one option that we used. We have a justice center model, and in the justice center model, we have a high court unit. In the high court unit, we employed experienced legal practitioners, not beginners, to serve the high court, because we were addressing this issue that legal aid lawyers are inexperienced, they're greenhorns, they know nothing. So that's why I'm saying I'm surprised that such a perception exists, because it's a long time since I've heard people saying the service offering of legal aid lawyers leaves much to be desired. But I know that they undergo serious performance measurement initiatives. They also undergo focused training in-house, and sometimes they source outsiders to come and train them on particular aspects. So that's the answer I can give you.
All right. Thank you very much. Good luck. From where I stand, I can see visible leadership. Thank you very much, DP.
Thank you very much.
Just a quick follow-up.
Thank you, Commissioner Dodovu.
Quick follow-up, Acting President.
Commissioner Mlambo.
JP, because this thing keeps on coming. On the matter of Commissioner Dodov,
Yes.
were you a presiding judge or you went there for case management?
I went there for case management.
Yes, thank you.
And his lawyer used the section 174 route to get him off the route, I think, if I'm not mistaken.
Yes,
I was
but you're not a
presiding.
president. It was
Judge
Judge Jackson Mabisel.
That's correct.
Yes.
Thank you, Commissioner Malema. Commissioner Nokes.
Thank you, President. Good evening, Judge President Mlambo.
Good evening, Commissioner Nokes.
I must, as well as it has been done by others, disclose that I have known you for many years. I serve you in the Legal Aid Board. I've known you for many years, and I hold high regard for yourself as a leader, as a judge president. JP, I will have few questions that I want to canvass. Perhaps if I may point out, I'm looking onto the submissions by CASAC and the DGRU. They do a very important job there when they outline some criteria that they say we should as well use. One of them, to which they both agree, is that first, the Chief Justice, the role of the Chief Justice includes A, being the head of the judiciary, to which we all agree, the head of the Constitutional Court, and the chairperson of the Judicial Service Commission. So in each of these three, I think we just have to reflect. As I understand from your plan, you dealt much on the first question as the head of the judiciary, where you outlined the plan, you talk broadly about the judiciary. We have not dealt extensively with B, that of the head of the Constitutional Court itself. I want us to focus briefly on that. And I will be looking on the requirements because others we have dealt with throughout the questions that have been asked. One where they say, among other things that you must possess, is that you must be an intellectual leadership, in considering that the candidate must be able to take intellectual leadership of the court to guide the trajectory of its jurisprudence and must have experience in broad range of areas. This must be assessed with reference to the candidate's judgments, but also publish academic or other extracurricular work. Now, my question is, from your questionnaire, you accept first that you haven't published any document.
Yes.
That you have no publication. The second point is that in your engagement with, I think is Commissioner Dunstan, you concede that you haven't written any judgment on socio-economic rights. You haven't written judgment there.
I mentioned one that I wrote when I was in the Labour Court.
No, you said you're right. That one concerns the equality.
No.
Which, the one of
what was that one? Yes.
What was that judgment?
That was the Congress of South African Trade Unions and the Western Cape government.
The one that
triggered the socio-economic rights protest action.
The one that protected drugs.
That is protected in terms of the LRA.
Mm-hmm.
Yes.
All right. And that must have been the judgment written sometimes in it's about 2012.
1998, I think.
1998. Yes. But in recent years, we haven't written any judgment in the area of socio-economic rights. Secondly, when I look onto the list of the judgments that you have written, particularly as the head of court, in most of those judgments that which I would categorize those judgments that turn on key issues, public interest, you always write there as the court. That is, you write a joint judgment.
Yes.
Now, my point is, how then would we, in such circumstances, how can we be in a position to meaningfully make this assessment in absence of recent judgment on the areas? Because that's what in the Constitutional Court you would be dealing with almost daily, questions of on socio-economic rights. Those are cases that will be going through that court on many of the time. How do we make that assessment? How do we mitigate the fact that we don't have information, but we do have an assurance from other work that you are a competent, you are a diligent, hard-working judge? But how do we balance that? Because we have to make that assessment.
Well, one aspect, and it's reality that you need to factor in that assessment, is that the socio-economic litigation that comes to the courts has basically dried up. It's a problem to have socio-economic litigation coming to the courts. I know that previous Chief Justices have mentioned this. So it can't be played on my door that I've not written any. I can't write something that hasn't come to me. That's one aspect I can mention as far as that is concerned. But in terms of judgment writing, I mean, if you're really looking for judgments where you just want my name as the scribe, you will struggle, because even in the Supreme Court of Appeal, where we sit as 5 in matters, you will be the scribe. You'll carry the burden of writing the judgment, but there'll be serious contributions into that judgment by other colleagues. You'll be the scribe. So I can't take it further than that. I've been involved in heavy lifting work, and I've mentioned that we allocate each other sections what to write, because it's a court judgment. And that's how we've dealt with these matters.
Now, there is the second question that I want us to debate here, relating to the complaint by the public protector.
Yes.
But not much about the complaint. Yeah. You receive a complaint. In fact, you allocate the bench, 3 judges, identified. Here are the 3 judges.
Yes.
I do understand once that is done, they are given the files.
Yes.
They take the files. Should you be further involved in that matter? Especially if the issue that arises concerns the proceedings, recusal of judges on allegations, which is part of the proceedings, or other aspects of the proceeding in relation, because what you have done, you have allocated the case, you have constituted a bench, it has a senior judge. It's fine, that is there. Why should you be further involved?
Well, I'm head of the court.
Yeah,
if the issue is raised with me as head of the court to say this matter is coming on in 2 months' time, this is the bench, we have a problem with the bench, I should be mindful to that. It happens all the time, Mr. Nojesi.
No, JP, let's get it right. Let's get it right. The independence of judges, as I would understand, include the process of the functioning of the judges themselves. Your duty there is that of administration, which is allocation. Once the case is allocated, it then becomes a part of those 3 judges. They have a senior judge. If there's somebody who wants one of the judges to recuse, you must go to court and make that application. It is a call that must be made by the judge who is being requested to recuse himself. You can't just come, somebody meet you somewhere or write to you and say, look, that judge, I'm not happy with him being in that matter. Whatever the reasons are, you can't just get in there. Am I wrong?
You are very wrong.
Okay.
Very, very wrong. Yeah. it's one of my responsibilities as head of court to say when these issues are raised, it's akin to me allocating the matter to judges. If it's raised to me before it's heard, and I think I mentioned a very important consideration to say the matter is given a date, and you want to avoid costs, time, delays in this thing being argued if you can already see that a case has been made out of a perception of bias. So you're wrong, Commissioner JSC. I can tell you I do it all the time, and it has nothing to do with with judicial independence.
Let's look onto that further before we leave. Do you accept that there is what we call forum shopping?
Yes.
And how does forum shopping arise, according to your experience?
Well, forum shopping is the reason that when we publish the duty roster in Gauteng, we don't mention the judges in the agent court role. For a simple reason that practitioners used to check who's in the agent court in a particular week. And then they will tailor-make their cases to be on that judge's role whenever it comes, because they perceive that judge to be sympathetic to their cause. That's forum shopping. Or to decide that I'm not going to launch my case in Pretoria, I'm going to launch in Johannesburg, when you can easily launch it in Pretoria. That's the classical interpretation of forum shopping. But asking for a judge to be removed from a panel is not forum shopping.
Yeah, but that's where my problem is. I mean, I'm sorry if we don't agree on this, I will leave. I will ask for the last time.
Yes.
Judges are located, they are given files. There is a senior judge in that panel. There is a panel.
Yes.
Somebody, for some reasons, is not happy with one of the judgment for one reason or the other.
Yes.
Is it the business of the judge president to come and say, that one must be removed from this?
It happens all the time. I don't see anything wrong with it, and I think it's one of my functions to say, if there's a well-motivated concern raised with a particular judge about that judge's participation in a matter, and I apply my mind, and sometimes I also consult the DJP, and if we agree, we say, okay, we tell the judge that, look, and we send the issue to the judge, say, look, there's this thing that's raised against you participating there, we think you should consider getting out. So let's agree to disagree.
We should.
Yeah.
We should. Now, let's move on to the question of the commitment to the Constitution.
Yes.
I'm just asking this question in relation to the order that you issued in that matter of the President of South Africa versus Public Protector, EFF. I look on the first order is that the application is dismissed, but my problem is with paragraph 2 of that order, where it is said, the President is directed to appoint a commission of inquiry within 30 days, headed by a judge solely selected by the Chief Justice, who shall provide one name to the President. Now, if one have regard to Section 83, 2F of the Constitution, that section empowers exclusively the President to appoint commissions, to deal with the appointment of commissions. Is that order, whatever the reason, I do understand from your previous explanation that you look onto the rationality of the remedial action, the reasons given by the public protector. But is the order itself not trampling upon the separation of powers? Is it not violating the separation of powers, constitutionally speaking?
Yes. I mentioned in my earlier response, Commissioner JSC, that the criticism of that judgment in academic circles is on that very point, on separation of arms, not on anything. And the criticism is that we did not discuss separation, the impact of our order in the separation of arms context.
Yes, yes.
And the answer is simple. The legal team of the public protector, no, not of the public protector, of the president that attacked the order, was solely focused on the legality of the remedial action that was issued. So we did not have the benefit of any argument on separation of arms in that case.
No, I read through that judgment briefly. They raised the issue of section 83(2).
Yes.
They raised the issue of the they raised the question of the powers, to whom the power of appointing the commission lies with.
Yes.
They do.
Yes.
But remember, JP, I'm not trying to review that judgment with you. I'm just trying to see if you reflect back onto this order, and understanding that now you are going to head the constitution. This is the reason why I'm asking. And the fact that that judgment was never appealed, the appeal, it seemed to have faded away. It did not proceed any further. That's why I'm asking.
Yes.
It's not for any reason to review it. No, I'm not.
Yes. No,
But I want you to reflect, to say, no, here it is correct that we did go far in this, but we have realized. That's all what I'm.
No. You want me to make that concession?
If you can.
If
you cannot, you can.
We applied our minds, and as I said, I sat in that matter. The pointed argument raised was not on separation of arms, but on legality of the remedial action.
Now, I think this will be my last question. We just focus on two things. One, you have never acted in the Constitutional Court. Your appointment, for which I must congratulate you, has just been recently made. I'm sure after your shortlist or your nomination, is that the position?
No, I knew in December when the...
In December this year?
In December last year, when the acting Chief Justice told me that...
yeah, but it was after.
Yeah.
But it was after the nomination has been made. Remember, in December, we've already even made the roadmap for these interviews.
Yes.
The point I'm trying to make is this. That appointment, of course for good reason, was it made to prepare you to understand the workings of the Constitutional Court, or it was just an ordinary appointment that they do in the ordinary course of events where they simply identify persons to act in the Constitutional Court?
Yes. Look, I can't answer that question. I didn't apply to be appointed to act in the Constitutional Court. The acting Chief Justice called me out of the blue to say the President, in fact, I think if I'm mistaken, you can clear it with him tomorrow, that I may also be wrong that I knew in December. I think the discussion was initiated by him to say, Mahleli, you should be happy to know that I've recommended you to be appointed to come and act in this court. That could have been before December. So I don't want to venture into the realm of speculation as to why I was appointed this time. I can't answer that question.
No, I'm asking this because somebody outside there, because your appointment was was made at the same time. It's your appointment and that of David. You appointed at the same time for this term.
Judge Unterhalt.
Yes, you appointed for this term. And one of the questions that were keeping on coming in the last interview for the Constitutional Court was one of whether a candidate has acted in that court or not. That was one of the questions that keep on coming. Now, on the face of it, somebody would say, look, this appointment
has been solely made to make these candidates, to prepare these candidates for the interviews. Because both of you, David is shortlisted for April, you are shortlisted for this one. It can be right or wrong, as you say, it's a speculation, you don't know. But it's what on the face of it would appear to be.
Yeah.
But there's nothing wrong about it.
If that's the speculation, I've not heard about it. But it remains speculation. You're busy putting seriously speculative notions to me. I can't respond to them.
Yeah. And then, this is my last question.
Commissioner Nogesi.
It's the last question. You know, one of the things I don't do, I don't even ask for follow-ups because I don't want to disturb. That's why.
Please pose your very last question.
It's the very last question.
Commissioner Nogesi.
It's very, very last question.
Thank you.
JP, this is the last question. This question, it relates only to if one is to fix a problem, one of the first things is to understand what the problem is.
Yes.
Now, among other things is to, you say you have to do is to fix the problem at the Constitutional Court, but I can vouch from where I'm sitting, you don't know the problems at the Constitutional Court. You haven't been there. You don't know what the problems are. You still need to be there so that to understand what the problems, particularly this time, will allow you that understanding how they operate, how they work, because it goes beyond the issue of reserved judgments. It goes to the question of how they make those judgments, the leave to appeals, all the things that precede the staffing, question of research, their capacity, and all those are the things that I cannot, meaning I would be unfair if I want to debate those matters with you now. So that's why I don't even want to debate with you now.
Well, I'm surprised you're adopting that because when I was asked about what I can do to fix that particular problem you mentioned at the Constitutional Court regarding delayed judgments, I agreed readily. Anyone sitting anywhere will know that there's a problem, that judgments are delayed. So I know that there's that problem. And I specifically said I'll engage colleagues to say, guys, there's this problem. Let's identify what's causing this problem and let's find remedial action to solve these problems. So it's incorrect to say I don't know what's happening there.
Thank you, JP. I have no further questions. Thank you very much, President.
Follow up.
Follow up.
Thank you, Commissioner Nogesi.
Follow up, Acting President.
Commissioner Mlambo.
Thank you. JP, I just want to make a quick follow-up. This morning you said any judge who cannot write does not have a place in the judiciary, like you don't deserve to be there. Am I correct? Am I quoting you correctly?
I said a judge who reserves for too long.
No, about writing. There was something you said about a judge who can't write, doesn't deserve to be there, but that's fine. I have a problem because part of what is going to be expected from you as a Chief Justice is to write judgments. And I need to know if you can write good judgments. And your answer now says, if you want the judgment that is me with my name there, you're going to struggle. Because even in the SCA, this is how we've done it. And in the Gauteng, this is how we've done it. But I thought to have a senior judge there, especially on these matters of national importance, which draw a lot of attention, is for that judge to write that judgment with the input of, then circulate to everyone, they will make input, but we know the custodian of this judgment is this senior judge. Especially on matters that you set on, which some of them have become a law in South Africa. Yet we can't say exclusively this judgment belongs to Judge Mlambo. How do we navigate that one? Because I really struggle to accept that you don't have a judgment that we can just run around with it and say, you can say all what you want to say, here is his judgment. Like yesterday, Judge Meyer says to us, I've sat on 600 matters, I've got 200 reported or something, then I've got 2 which got reported in a green book, the same volume, following each other, which is very rare. Now this person is already inciting you to go and check, what were these matters that got reported on the same book, which is very rare. She says it's her, and Judge so-and-so have ever done that. You know, that judgment is her judgment. Now, which judgment can we just, when living here, say, this one, it's the one that we're going to find the name of JP Mlambo and not the name of the court, where they say it's a court judgment. Because it's really a troublesome, JP. I think it's an opportunity for you to shine and say to us, not the following judgments. If you want to know who I am and how I write, go to the following judgments. Because now if it's a court judgment, I can't sit here and say to you, okay, which portion was written by you in this court judgment? Because I wouldn't know which portion is yours.
I think you have made your point. Let Judge President Mlambo respond. Thank you.
Thank you very much, Commissioner Malema. I can write judgments. I have written judgments. It's a style of judgment writing which I adopted when I became head of court, especially in Gauteng, that when I put full courts, I make sure that we write court judgments, not just individual judgments. You can criticize me for doing that, but it serves a very beneficial value to do things that way. But you want judgments in my name? There's a lot of them. In the LAC, the Barnard case, I wrote it for the LAC, the one that went all the way to the Constitutional Court and was upheld. And there's a lot of them in the SCA that I sat in, that I wrote. So I invite you to go and look at all those judgments. I wrote those judgments. And even now, where I sat alone in Gauteng, I wrote those judgments.
Thank you, Commissioner Malema. Judge President Mlambo, I said good morning to you when I welcomed you earlier this morning. So I think it would be proper for me to say good evening before I pose some few questions to you.
Sorry, Acting President. There were 2 follow-ups this side. Quick ones. If you are wrapping up.
Who?
It was Matonsela and me.
Yes, Commissioner Matonza.
Yes, Judge, thank you, Deputy President. Judge President Mlambo, I've been resisting to make this comment. It is worrying me. Is it correct to say that a judgment relating to the right of employees to protest engages the socio-economic rights? Is it a socio-economic right to protest?
Yes. Because the right embedded in the protest action was the provision of sporting facilities and recreational facilities in black schools.
I thought a social economic right was a right that engaged resource allocation by the state.
Providing sporting facilities, doesn't that engage socio-economic rights?
Well, I beg to, I'm sorry, I really struggle with the concept. I think in my book, the right to protest is not a socio-economic right.
To protest to achieve what?
Just bear with me, Judge President Mlambo. I think we should leave it at that. Otherwise, you are now, engaged in a dialogue with Judge President Mlambo.
Thank you.
Thank you.
Yes.
Commissioner Bof.
Thank you. Mine is a very quick one, Acting President. JP, good evening again.
Good evening, Commissioner Bof.
Yes, a very, very quick one again. When Commissioner Njesi spoke to you about how it got about that you are acting in the Constitutional Court. You answered that sometime in December, the acting Chief Justice called you and said, the President, and then you stopped. What was that? What did the acting Chief Justice say?
I think you remember I corrected myself. I think he called me to say, you have been appointed. But as I say, I then went back to say, actually he had called me previously to say, I have recommended your appointment in the Constitutional Court. So I can't remember whether it was November, right? So I was going to say, he called me to say, you have been appointed, I'm just waiting for the letter from the President.
Thank you.
Thank you, Commissioner Mbofu. Judge President Mlambo, during your presentation of your vision, you mentioned that something about corruption within the court operations, and as an instance of that, you mentioned the issuance of fraudulent court orders. What I want to know from you is whether any measures have been put in place to minimize, if not to entirely eliminate, that problem.
Well, what we've requested, those, especially banks and the Department of Home Affairs, I think, is whenever they receive orders seeking either person saying we are married to a South African or whatever, they should double check the authenticity of that court order. Because sitting from where I am, I can't prevent people trying to fraudulently produce court orders like that look like court orders. But what we have done, wherever we have discovered that there have been orders that are masquerading as court orders, and we can identify the people who use those court orders, we've gone to the police station to open cases, and we've requested the police to expedite the investigation and refer the matter to the prosecution. We've done that. You remember early on, because I chair that committee, it's called the Court Order Integrity Committee. We made submissions to SABC some years ago, probably 8 years ago, to say they must regard conduct that deals with fraudulent activities relating to court operations as priority crimes. And that was acceded to. So in keeping with that, we have requested the police to make sure that they expedite the investigation and arrest, if possible, and the prosecution of those matters.
Thank you. Reserving a judgment for upward of 2 years, does this not verge on subversion of the course of justice?
Well, it can be viewed as that. I think it was in that context when I said a judge who cannot write. I was meaning if you've heard a matter and you can't write the judgment, you don't belong in the judicial space. It's completely unacceptable to do that.
And my follow-up question to you on that aspect, could one therefore make out a case that when a judge cannot perform his or her core function, which is to go to court, hear cases, render a judgment, that judge suffers from incapacity as contemplated in Section 177(1) of the Constitution?
Yes, that's why I mentioned 2 cases that I've referred, where I am the complainant as the JP, that these judges consistently reserve judgments upwards of 1 year to 2, and longer in certain instances. And I know that my division is not the only division. that has judges who reserve for very long periods.
Yes. If that is prevalent, which is the impression that I gain from what you have said, is it not a matter which should be treated with the utmost urgency, lest the judiciary is brought into disrepute?
That is correct. That's why I took it upon myself to refer a complaint, and the matter is no longer in my hands.
During the course of the questioning, it was suggested to you that litigants choose to litigate in Gauteng because you, as the judge president, would pick and choose judges, knowing that those judges would ensure that a predetermined outcome is achieved. Doesn't that suggestion impugns not only your integrity, but the integrity of the judges to whom those matters are assigned?
Well, it does, unfortunately, but it's an unfounded perception that all matters are predetermined that are heard in Gauteng.
Because its implication, in my view, is that suggests that there is some form of collusion or connivance amongst all of those judges.
Yes. And I think a follow-up issue I can raise is, if indeed there is such collusion, I think one shouldn't exclude an investigation as to how those matters have fared on appeal.
Yes, in fact, that was going to be my next point, because Chapter 8 of the Constitution, apart from establishing courts as the judicial authority, goes further to establish the various courts, your constitutional court as the apex court, your Supreme Court of Appeal, the high courts. So litigants, if dissatisfied with the outcomes of the litigation in the court of first instance, they have got the full court, the SCA, and the constitutional court.
That is correct, Acting President, and from where I sit, in those matters that I've heard, except for the state capture judgment, which I think never went on appeal, in all the others, I think it was upheld upstairs.
In matters that you classified as intellectually challenging, in which you presided, you still managed to render your judgments expeditiously.
Yes.
At some point, a point which was an aspect which was probed by Commissioner Barnett, you said that judges are backstabbers, gossip mongers. Is that statement not sweeping and too general, impugning the integrity of some 240, 250 South African judges? Because quite frankly, speaking for myself, I find it extremely offensive. because it paints all the judges of the country with the same brush.
I think my answer was there is backstabbing and gossip in the legal profession. That includes judges, lawyers, advocates. So I don't think I can be heard to have said everyone in the judiciary is a backstabber or a gossiper. The fact of the matter is it happens. And that's how I would like my response to be understood.
But then, Judge President Mlambo, when you say judges, I would have understood if you had said some judges, not judges. Because the implication, if you say judges, is all of the 240, 250 judges in this country.
Well, I think I take your point, Acting President. Perhaps it's unfortunate usage of sweeping language. And I take your point that perhaps I should have said there is backstabbing and gossip mongering among some members of the judiciary.
Thank you, Judge President Mlambo. Do you have anything else you would wish to say that may, in your view, be of assistance to us during our deliberations before we adjourn the proceedings?
Thank you very much for that opportunity. I think what I would like to say to this commission is they've heard me today. They've listened to me, they've explored my candidature from all angles. And I want to believe that I gave it my all. I answered all questions put to me. I want to believe I possess, and my experience in leadership circles equips me eminently to be appointed or to be recommended for appointment as Chief Justice. I want to believe that I provided a credible and context-specific vision for how one can look and fix some of the problems that are there in the judiciary, as well as maximize on the good aspects of what the judiciary in South Africa has achieved thus far. So with those few words, I think I've given it my all. I've answered all questions put to me, and I can't take it further than that.
Thank you, Judge President Mlambo, for availing yourself and for your answers to the questions posed to you by the members of the Commission, some of which, I must say, were difficult questions. So all of that will be taken into account during our deliberations. You are at this stage excused. Thank you very much.
Thank you very much, Acting President and Commissioners.
Fellow Commissioners, this brings us to the end of our sitting today. So we are adjourning at this stage to continue tomorrow morning. Is it 8, 7:30 tomorrow? Oh, 9. At 9. Thank you. Until 9 o'clock in the morning.
The House is adjourned, Madam Speaker.
Acting President.